collectively building the sustainable common future that Judge Veeramantri dreamt of. Welcome.
Mr. Vipin, of the
Namaskar, Ayubhavan and Vanakkam. This country has always welcomed its visitors. And two of the Chief Justices of the greatest democracies are together. And as Lord Chief Justice Surya Kant had said in the Sri Lankan Colombo Summit, that what we need now is regional ecological constitutionalism. We hope and pray that this day will be welcome to you and you take it to a different level. Welcome.
Thank you very much. On behalf of the Supreme Court of India, the Indian judiciary, and on behalf of course, the Bar, the Supreme Court Bar Association, the SCORA, I welcome Justice Padman Sosena, Honorable Chief Justice of Sri Lanka, Justice Tera Raja, Justice Sampath, Justice Sobhita Rajkamana, our only sister in the Supreme Court of Sri Lanka, Justice Menka Vijayasundara, Justice Nawaz, Justice Mahinda Samarvardhana, Justice Sampath, Justice Arjuna, and Justice Shiran Gunratne of the Supreme Court of Sri Lanka. We hope that your visit to India has been quite meaningful and very constructive in terms of the dialogue that we have initiated between the two judiciaries for the purpose of exchange of the best of the practices, and particularly that our commitment to provide the technological infusion in the global judiciary, and particularly our neighboring and our countries with whom we have a very historical, emotional and sentimental bondage in terms of familiarity, paternity, and that we maintain and promote the same cultural values and ethics. Thank you very much, Chief Justice Susena and my brother and sister judges for joining us. Thank you.
My Lord, the Chief Justice of India, Justice Surya Kant, Your Lordship Bagchi, Honorable Attorney General Mr. Venkataraman, the Honorable Solicitor General Mehtra, Ashok Mehtra, the President of the Advocates Association of the Supreme Court and their Secretary, the senior advocates, the ladies and gentlemen. It's indeed a great pleasure for me and for my sister and brothers to be here. India is our closest neighbor and also the closest friend. The bonds between people of two countries dates back more than 2,500 years. And this bond was persistent not only between people, but between rulers, kings, and even emperors. And this morning, His Lordship Justice Bagchi reminded me, he comes from the state of Bengal, where the port was situated. It is from that port really, Emperor Ashok's son Mahinda and daughter Sangamita went to northern part of Sri Lanka by boat. And day before yesterday, we visited Sanchi in Madhya Pradesh, and this Bodhi sapling, which was taken from Bodh Gaya, was deposited in Sanchi before it was transmitted to that port in Bengal and transmitted to Sri Lanka. And that happened in 3rd century. And even Sri Lanka is known in India because it is the setting in Ramayana, which actually dates back to the era before the cities came up. So that was the bond between these two countries. Then to come back to the connections between two judiciaries. And in at least the last 2 decades, we have started interacting with each other, the judiciary. And some of us were here for His Lordship's swearing in. And before that, immediately before that, just 1 month before His Lordship took oath, His Lordship came down to Colombo in Sri Lanka and attended the National Law Conference in Kandy, the Central Hills. And His Lordship made a very vibrant speech, also like this on the bench of the Supreme Court and also in the National Law Conference, and which fascinated the members of the bar and the judges alike. And it is in that respect that we associated him. And then and on the last week, I think, the 2 weeks before we participated, the Constitutional Day organized by the Bar Association of the Advocates of the Supreme Court. And we were warmly welcomed, and Honorable Attorney General was pleased to approach us and talk by himself. And so is Solicitor General. And we felt the friendship. And we went and narrated this friendliness and how we treated and the closeness to our council, the sisters and brothers. So they were very much interested in coming personally and seeing CJS courthouse. So having said that, I know all are waiting, all are busy and busy days. So we just crashed in. Thank you very much for all the sentiments, and we take great pride, great pleasure to be here. And thank you very much. Thank you very much.
Thank you. We can resume the court proceeding.
Before item 1, my lords, may I seek my lords' indulgence for mentioning, my lords. Item number 8, my lords, I appear for the petitioner, my lords, the state of West Bengal. I apologize, I'm standing here. My lords, I've informed the other side, my lords, may I seek a date in any time in January, my lords.
What is item 8?
My lords, the matter is under the West Bengal Estate Acquisition Act, my lords, where certain acres of land was awarded to a third party.
Assumption of land was set aside.
Yes, my lords. I've informed the other.
When do you want?
My lords, any time in January or February, my lords.
Have you filed your counter?
Yes, my lords, the pleadings are completed. Written submissions have been filed, my lords.
Pleadings are complete. On the joint request made by counsel for the party. The other party also.
Yes, my lords, I believe I've informed the other side, Mr. Anupam.
Once your London State Council informs that he has already taken consent from the council appointed. She seeks and granted 4 weeks time. Post the matter for hearing also do.
Obliged.
State Leader, I appear for the state of Tripura. What happened was in between, the Lordship, a bunch of matters came in, this matter got tagged. Now there was General Singh 1 Constitution Bench, then 3 judges, General Singh 2 as we call it. It has clarified to a large extent to what the problem, 9 questions were raised by the High Court full bench. I was only requesting, let this be de-tagged.
The Constitution bench has already clarified.
That's clarified because they said Nagaraj's last portion should not be read as mandatory. General Singh 2 also does it, but
Well, I post this matter for final hearing.
all the matters, no, all the matters, that's where it gets,
It's already there.
only Tripura should come up separately.
Specific
We have filed the early hearing application.
from the bunch.
Exactly.
Let this be taken up in isolation, otherwise it gets modified.
Not all matters may be kept on same day. On that day, we will assist your lordships in undertaking an exercise
One by one you want.
of segregating,
Segregate.
if it can be segregated in groups, my lord, so that it would be more methodical.
How many,
As far as that.
approximately how many items are there?
About 150 matters.
Matters. Different, they are different.
150 matters.
Total of, let us say, 18 states where this problem has arisen. Out of which 100 people are intervening, there are other cross SLPs. I was suggesting this one, let Tripura be taken up as the item one, because I have moved the application. Nobody else was, they were all sleeping up till now.
No, we have
Just
also,
1 minute.
we have also.
I have moved the application, could your lordship have this as item number one at the.
Mr. Rana, anyway, that you have taken initiative, that's a good thing.
No.
But eventually all these matters have to be taken up.
But I say my issue is
But
narrow.
there is, the issue broadly is common. There will be overlapping in terms of submissions also. So instead of taking in piecemeal all the matters, we can take up on one date and we will take care of your problem also. Then on that day, we can take one by one. That if in Tripura matter, you find that there is something, some distinguishable issue, we'll take up that also.
Could I request them not to Jayanti Chakravarti, this matter be taken up as the first item, because it was first earlier, Sari Lakshmi Narayan.
Your item incidentally is one. It will continue to have the same numbering.
Insofar as what is 1.1, one is, I
1.
thought the other matter has come up.
1.1 is all right, 1.1 is also one.
I know that.
Lord, insofar as
No objection.
insofar as Tripura matter is concerned,
Item 1.
Lord, I have filed 3 applications. There was a status quo order passed at the time when notice was issued, which is continuing. Despite that, Lord, they introduced some ad hoc policy with respect to promotions. Now that ad hoc policy is thought to be made permanent, Lord, and that we have come out with an seeking stay of that particular notification of 1st of December.
Mr. Average, when we are thinking of deciding the main case itself, if there are 150 matters, why should we keep them pending at all?
Tripura matters are not.
So Tripura matter may not be, but overall batch of cases, if it is 100 plus matters and pertaining to only on the issue of reservation in promotion, maybe that formulation of.
My lord, can I explain the problem in 2 sentences?
These applications, my lord.
Can I just explain the problem in 2 sentences? My lords, in Journal Singh 2, what your lordship said is that you should have data to support promotion.
That's right.
But the data should not be class-wise, but should be cadre-wise. Many of these states have data. Whether it falls within that or the other, your lordships may have to decide, or your lordships may have to say, okay, do a fresh exercise. But that's broadly where the controversy lies. So,
So some of the states might be having data readily available.
Yes.
And others don't have. There can be a time-bound direction. They can undertake that exercise and then give effect to whatever they want.
One essential feature. Just one.
Lord,
18.
insofar as Tripura is concerned, I said
74%.
the 2 applications are
not. 74% vacancies is not allowed, so we are not being able to fill it up. It cannot continue by not standardized. 74% at page 5, not by page 18.
All right, let's not own the listing itself. Why should we spend so much time?
those 2 applications
We'll
filed
take up-
by us are directed to be listed tomorrow.
We will take up on 21st January.
25.
oblige.
Lord, 2 applications are already directed to be listed tomorrow.
Now that we might be, we are talking of the main case.
Very well.
Say the prayer for early hearing allowed. The main case along with all the connected matters is ordered to be listed on 21st January 26.
The detagging can be.
My lords, it will have to be a 3-judge bench. It will have to be a 3-judge bench.
In January, that's why we are listening.
Please, my lords.
You are aware of that. It's a 3-judge bench.
It may be a good idea to keep it specifically at 2 o'clock so that the rest of the board.
That's why on Wednesday we are listing.
Oblige.
We can continue for 2 days. 21st and 22nd.
Make it easier for your lordship to really, we'll file a synopsis.
Yes.
Each case.
And
Obliged, your lordship.
my lord, we are fully obliged because this matter is pending from 2014, my lord. I am representing state of MP as a special counsel and state of Chhattisgarh also, my lord.
We'll try to dispose.
And
of
all from 2024 till today, my lord, all the promotion is blocked. This is why we are obliged, my lord.
We will take up, don't worry, we will take up those. Item 2.
This is an early hearing application, Maluds. I'm appearing on behalf of the liquidator. Your lordships had issued notice in 2021. And Malud, since then it's being held in abeyance. So it's been about 5 years.
It's listed some 3 times, my lords. The appellants had taken some adjournments.
So now what's happened is that from 2021 now there's been a status quo. So that's where my difficulty is.
Post on 15th January.
Grateful, my lords.
15th January as per us.
Deeply grateful.
Next.
The other side has moved another early hearing after it was dismissed in May.
There is no. There is no urgency in this matter.
There is no, they dismissed in May, my lords, their early hearing. Again, another one moved by them after a reasoned order marathon hearing. The stay order was passed, my lords, after hearing all sides. Now they want an early hearing under 24 appeal.
There is stay operating, that's why.
Yes, my lord.
Yes, please. My lords, senior is through VC.
In early hearing, why senior is appearing? I don't know.
My lord, this is a case where, my lord, this stone crusher is operating, lord, in a silence zone, my lord.
It's all right.
Your lordship's order is, my lord, November 2021. Lord, twice these stone crushers have, lord, from the village. And lord, they are lord, within 100 meters from the lord, government school, primary school and government. And my
problem is that in the online you don't listen to us. You only, please don't create one-way traffic. In how many, is it humanly possible to take up all the cases together? So we'll have to segregate them and list some of the matters where there is no grave urgency. Let those matters come as per their turn.
My
List as per turn.
environmental case, my lord.
All right, thank you very much. Thank you. Item, next item.
Item 14.
Application 11 years in custody.
Why appeal has not been heard?
Item 4, my lords. It's an application for early hearing. My bail
Why bail application not being heard?
application, my lords. My lords, may kindly see.
Rejected 2 times.
My lords, the bail application is also kept pending.
Just a minute. Yes.
I have no objection for early hearing, my lord. Record is there. It can be posted in the month of January, my lord.
No, but why bail application is being
Bail
approved?
application was rejected 2 times, my lord.
Why?
The other,
Because looking to the evidence on record, my lord. Evidence on record. Two
No, evidence on record maybe that's why he is in criminal appeal before us. He has spent 11 years in custody.
Yes, my lord, concurrent orders are.
Read out. Early hearing application to the extent of listing of the bail application. What is the number of bail application?
No, there is no separate bail application.
separate bail application is also pending, my lord. This is an early hearing
Your
application
bail application is also pending.
is also pending.
Just give the number of the bail application.
IA 15127.
19.
What
One-
is the fate of IA 15127?
That is rejected, my lord.
192473 is pending.
Say like this, hurdle and process for the parties. The prayer for early hearing
Yeah, that-
allowed in part to the extent that bail application bearing IA number, give us the number,
192473 of 2025,
the one which is pending,
which is pending.
is taken on board. Then write down. The prayer in this is taken on board for disposal, final disposal. Then say the petitioner is a convict under section 302, read with section so and so IPC,
Kindly see the previous.
and has been sentenced to undergo life imprisonment. The allegations are that he assaulted the deceased, in bracket Angad, along with co-accused, motive is attributed, alleging that the parties had a dispute on account of non-payment of hospital expenses by the accused persons to the deceased. The petitioner was held guilty by the Sessions Court, while the judgment dated so and so, against which his criminal appeal held before the High Court, against which his criminal appeal number 598 of 2016 also held before the High Court. The aggrieved petitioner has filed the special petition, the instant special petition. It is not in dispute that the petitioner has spent almost 11 years in custody.
10 years, 5 months. 10 years, 5 months.
10 years, 5 months in custody. The final hearing might take some time. Having regard to the period already spent, the petition is directed to be released on bail, subject to its furnishing bail bonds to the satisfaction of the trial court. The special petition is directed to be listed for final hearing.
Criminal appeal. It is a criminal appeal.
Criminal appeal. 29 July, there was a criminal appeal.
Appeal will be listed in due course of time.
You say, Your Lordship, in the month of May or April.
There is no need that. How many appeal will?
Yes,
My lords, this is with regard to the.
Say that look into the role played by this appellant only, because there were so many other convicted persons in this proceeding. They have not filed the, especially.
Why are you opposing bail application in a case person has spent 10, 11 years?
I am saying that looking to the role attributed to this.
My lords may kindly not make.
He is the principal accused, there is no doubt about it.
No,
He is not the.
no, he is a co-accused, my lord, principal.
Then you can say, having regard to the role attributed to the applicant petitioner, appellant, and coupled with the fact that he has already spent 10 years, 5 months, or without expressing any opinion on merits.
Grateful.
He is directed to be released from bail. Item 5.
Please, Your Lordship. My lords, this is the matter where the challenge to the online prohibition of gaming. My lords, it was before Justice Pardiwala, the whole matters, and his lordship had directed to be listed high on board. However, it's suddenly gone off his board. We were told, my lord, we have to move for an early hearing and fixing a date before my lords. Although it was on his lordship's board, and his lordship had also passed an order to high on board for hearing on 26th November.
This matter pertains to the challenge to the virus.
Challenge to the prohibition of online gaming. Virus.
Through a statutory intervention.
Absolutely.
What has happened is the act has not been notified, but it is all the banks, everything is shut down. So we have lost 300 people have lost their jobs. It is complete uncertainty.
So I will list it in January.
Please.
It should go ordinarily before a 3-judge bench. Constitutionality.
What happened was
The early
was heard by the same bench.
Because, my lords, earlier was the GST issue. The entire issue of GST and, my lords, the states had prohibited.
But at that time, this 25 enactment was not there.
I'll explain.
I recollect those matters once came before my bench. I was sitting with Chief and CJI.
My lord, and then what happened was the states of Karnataka and Tamil Nadu passed acts prohibiting online gaming. Those, my lords, had been decided against the state by the high courts, and those appeals came up. His Lordship Justice Pardiwala heard those appeals and has reserved judgment in those matters also. That was challenging the state acts.
That judgment will definitely enlighten us on the issue.
They both will be connected. That both will be connected, which is why His Lordship said this should be listed high on board, because the act of the same effect by the central government now.
Call because the virus matter I am thinking of listing before 3-judge benches. As a matter of policy, most of the statutes wherever this issue is coming. But let's see, meanwhile, let's hope for...
My lord, sir, only urgency is only we pleading urgency because people are all unemployed now.
No, I will list them only in January, and meanwhile, I will decide the composition and everything.
Your Lordship is right. It should better to go 3-judge bench. Only thing in this matter, it was heard for several weeks. All of us argued also.
That was on the
State
taxation aspect.
No, on the state
on
validity
prohibition.
also it came. We have no problem to come with 3 judges also. But we are just saying that this was first posted before that bench. We filed all the pleadings. And here what's happening is the state validity came of them. Your Lordship may post before this because they heard the whole thing at length. Betting, gambling, the parliament has competence because betting and gambling is a state.
Whether it's entry 34 or entry 21 of list 1 or 34.
Has been exhaustively argued.
No, the matter which has been argued where the judgment is awaited, that would, is that judgment also going to give any opinion with respect to the power of the state?
State. In fact, my lord, that is the exact point. In that particular state, in that particular judgment, one of the arguments I had taken up in that case was lack of competence, legislative competence of the state for online gaming. Here the center is, and that's an argument being taken here, whether the center has the legislative competence.
Therefore, Mr. Sundaram, within our federal structure, if they ultimately your argument is accepted that state is incompetent,
yes,
then at least center will...
Absolutely. Therefore, the two were connected, which is why His Lordship said he'll hear this matter so he can decide both.
So let us have the opinion that whether the state is competent or not. Because if the state is held to be competent, then there will be some questionable issues with respect to central law.
Which is why his lordship said, list this matter also so that he can decide it both, because the other is saying state is incompetent. Here the question is whether the center is competent, union is competent.
Just one supplement. It may not be just legislative competence of legislature vis-a-vis parliament. The parliament has gone beyond that, my lord, which is not there in the state. So it would be a separate issue and separate argument.
Lord, may I just mention one thing?
Anyway, we'll list the matter.
Basic point, Lord, is betting and gambling is a state subject. And we said that it's a game of skill. It can't be betting and gambling.
See that my decision to list all these matters.
In the month of January, if at all possible, my lord.
January, we are.
I'm very,
Everything is shut down.
very obliged.
Everything is shut down.
So we are listing in January. That's what I'm
Very
promising.
Great.
The state has filed a status
As per the previous status report, Manoj, 23 witnesses were examined. Now the latest one says that number is risen to 36.
So what about your that forensic examination report?
Yes, that's still awaited, Manoj. That has been sent. The voice sample has been sent. That is in respect of the third FIR.
All right down. In compliance to order dated 9th October 2025, the state of Uttar Pradesh has filed a status report.
Manoj had in fact directed us to informally find out about the pendency of matters before the concerned judge. We found out 789 trials are pending before him.
789 trials before one presiding officer.
What I know.
No, but now they have pruned the list, my lord.
Now we are being there. How one of presiding court will able to cope with that?
In 2 months, he has examined 13 witnesses, which are
36 with me.
no, in 2 months. From
737.
From 23, it's gone up to 36 now.
Now I think we'll go some material.
Yeah. 16 to
In opposite order which we are passing from time to time, that means the other 700 some plus trials are being. I don't know what is the fate of those cases.
I've been respectfully submitting that, Manoj. The other side which wants a special trial to take place, Manoj, we said there are 700 cases pending. I've been arguing that, yet the trial judge is making an enormous effort.
Can you, otherwise, there is some there is one public interest litigation. Just note down. That those two, I'm dealing with the constitution of some specialized courts, dealing with the central laws of the UAPA, NDPS, PMLA. I would like to take up this issue also. And there is another matter of judicial infrastructure. That how many total trials are pending in state of Uttar Pradesh?
Yes,
each court is how many matters are decided. And then why not you please think of creating some additional courts then?
Yes, ma'am.
Because it's humanly impossible for one trial just to deal with so many trials.
Absolutely.
And now there's an added problem. Special courts in MP, MLA, Manoj. Now MP, MLA courts, the docket is all clogged. And one judge is specially.
No, that I'm taking care. That matter has in fact with the lot of cooperation and very supportive approach so far as we could see from the central government also. I have directed them to establish and provide us additional infrastructure for establishment of exclusive courts to deal with
MPM.
trials under the UAPA,
Yes.
MPMLA,
Yes.
and this NIA, and of course the NDPS. All these specialized statutes. And those courts will not be assigned any other matter except though trial.
I know when your lordships were in court 2, it had started from court 2. It is there.
I'm quite hopeful that very soon some formal decision must be taken at the level of the central government. And once we get that matter is also coming before us very soon.
But this matter is not going there, Manoj, is it?
No. This will be because the state issue.
Yes.
This is not about the central penal laws of where those specialized courts are required to be established. I don't see in compliance of the order dated 9th October 25, the state of Uttar Pradesh has filed a status report. according to which the investigation of FIR number 658/2025, that in the course of investigation of FIR number so and so, the statements of all relevant witnesses have been recorded. And as regard to the alleged threat extended to a witness in the main case, the report of forensic examination is awaited. Due to this reason, the investigation is still under progress. So far as the main trial is concerned, 36 witnesses have already been examined, 10 have been exempted, and 85 are awaiting examination. This is in FIR number 219. Don't see main case. In so far as main case, that is FIR number 219, 2021. Similarly, in FIR number 220 of 2021, 35 witnesses will be examined, out of which 25 have already deposed and 10 are awaiting examination. Next paragraph. With reference to the oral observations made on the previous date of hearing, learned additional advocate general and senior additional advocate general for the state of UP informs that 789 trials are pending before the same presiding officer, before whom the subject trial is also undergoing. We will not make any comment in this case about this part. We'll see. Please keep in somewhere in March.
May I make a prayer, my lords, that since I'm out now for 5 years, between 25th and 1st, can I go to Lakhimpur, my lords, which your lordships had relaxed for Diwali by the order of 9, 10, 25, at least for a week, because my daughter is in the 12th. she needs some sort of guidance.
So when do you want to go?
On 25th December to 1st January, I'll come back, my lords.
Let the petition, meanwhile, the petitioner is permitted to visit and stay at Lakhimpur Kheri with his family from 25th December to 31st December, subject to the same terms and conditions which have already been imposed.
Lordship, please. I'm obliged, my lords. Grateful.
Please, my lords. But in this matter, my lords, I seek bail where everybody else has got bail. In this matter, my lords, this arose out of a business rivalry. The businessman has got bail. The actual shooter has got bail.
Antecedents. Otherwise,
the antecedents of the other also were, despite that, they've got bail. As far as I am concerned, in this matter, the only thing attributed against me is my statement to the police saying that somebody will arrange the money. That, if your lordship sees page 68.
So are you not the sharpshooter involved in killing?
I'm not the sharpshooter. The sharpshooter has already got bail. Page 99.
Is it the case that that businessman was killed because of the business rivalry?
Yes, my lord. And the businessman got bail.
Where we granted bail to the main accused also.
Yes, my lords.
No, of course you have come late to us. Yes. But I think last time also, Mr. Yogendra, the only issue that we were likely that we expressed.
Your lordships thought that I was the shooter. I am not the shooter.
Not only the shooter, the other people was your 25 cases. 23 to 88.
In 13 of them,
Page 83 to 88, Mr. Head.
Please, my lords. In 13 of them, I've been acquitted, and your lordships would see.
7 of them are attempt to murder or murder cases.
My lords, please see in this particular thing, if your lordship kindly sees page 68. If your lordship sees page 68, what is the material against me? Bottom of 68.
Yes.
The eyewitness who's turned hostile. 50. 1 minute.
Rajasthan.
I'm from Jaipur. I can stay outside the state of Madhya Pradesh, except for I can stay outside the state of Madhya Pradesh, my lords. That's not an issue at all.
But we can do, see, probably we can't keep him indefinitely.
Yes, sir.
The only thing is that going by his antecedents, he is a threat, he can be a threat to the society.
Yes, sir.
The moment he is out, he can indulge because whatever the background he has. But let us test him. We are thinking of releasing only on interim bail. Subject to his reporting every week to the local police station and will allow the police to have some surveillance on his activities.
Please, Malad.
Yes, sir.
In Rajasthan or in Madhya Pradesh?
In Rajasthan.
Obliged.
You must stay at your hometown.
Absolutely.
Must report to your local because he can mend with only with the peer pressure. That's all.
No, I entirely agree. I entirely agree.
But he will appear before the trial court.
Please, my lords, just one more clarification for your, my lords, the main witness has turned hostile when I'm inside. So there is not.
Mr. Hegde, you know very well how they operate from inside also.
Please, my lords, I will stay in Rajasthan. All the remaining witnesses are policemen. That's what I actually should have said.
Say, the petitioner seeks enlargement on bail in FIR crime number 52/2019, registered at police station Vijayanagar, district Indore, under section 307, 302, 120 capital B, that is section 34 of the IPC and section 25 and 27 of the Arms Act. The petitioner was arrested on 29th April 2023.
Yeah.
And thus has spent
Thana Kalwad.
more than
2 years, 7 months.
6 months. 2 years and 6 months.
Yes.
Next paragraph. It is true that the main accused or some of the co-accused of the petitioner have already been enlarged on bail. However, we are not inclined to release the petitioner on regular bail at this stage. Or we are not inclined to release the petitioner regular bail at this stage, owing to the fact that he is stated to be involved in 26 criminal cases, mostly of heinous crime like 307 or 302 IPC. However, with a view to accord liberty, subject to certain conditions, and with a view to closely watch the conduct of the petitioner upon being released, we direct the petitioner to be released on interim bail, subject to the following condition. One, he will furnish the petitioner directed to furnish bail bond to the satisfaction of the trial court. The sureties to be produced by the petitioner must be persons of credentials in society. Two, the petitioner will stay
Page 60.
at his village.
Resident of 11 Sundar Vihar, Kalawad Road, Machna City, Jaipur, Thana Kalawad.
The petitioner will report once in a week, that is on every Saturday, to the jurisdictional police station.
Police station, the number.
Jurisdictional police station.
Kalwad.
The petitioner shall also furnish his mobile number to the local police station as well as to the trial court. Next paragraph. The petitioner shall remain present before the trial court on each and every date of hearing. Next paragraph. The local police as well as the police authorities in the state of Madhya Pradesh, the the police of the states of Rajasthan and Madhya Pradesh shall be at liberty to have a vote on the day-to-day activities of the petitioner to ensure that it does not indulge. Just say activity. Next paragraph. It is made clear that if the petitioner is found involved in any offense, in any crime, comma, this order shall be deemed to have been automatically withdrawn, and the police authority shall be at liberty to arrest him if it amounts to commission of a cognizable offense. Next paragraph. The petitioner's advocate will extend full cooperation to the trial court, and in the event of any delaying tactics or non-cooperation, the trial court shall be at liberty to send a report to this court, whereupon also be inferred that the petitioner has misused the concession of bail. Next paragraph. The passport of the petitioner shall be deposited in the court. The passport, if any.
I don't have a passport, if any.
If any, shall be deposited with the court. Next paragraph. The petitioner shall not leave the state of Rajasthan, except for attending the trial court in Madhya Pradesh, without prior information and permission of the local police as well as the trial court. Post the matter in March. You submit a report to us about conduct.
We'll do that.
The state council will ensure that a status report by the local police with respect to the conduct of the petitioner while on interim bail be furnished to the court.
I'll oblige your lordships.
Grateful, man.
May I please, Lord? Lord, two very humble submissions Lord, in this case.
ये तो करते नहीं ना हमारे प्लेस में ऑन उसकी भाई इक्विपमेंट आप या तो बैठ जाइए इस खड़े नहीं रहना चलो
Lords, I assist on behalf of the brother of the deceased. I had enough.
The ultimate issue is that whether the victim deceased, whether he committed suicide, or one, two, whether he was forced to commit suicide, it can also be an issue. And third can be whether it was a case of murder, which probably you are not also not realizing. You are also saying that the circumstances were created in such a manner that he was forced to commit suicide.
That is certainly the case of the state, my lord.
Now,
in terms
unfortunately,
of in the case diary.
Unfortunately, in the first investigation,
yes,
which of course you have your reasons to allege.
In regard of the first case, my lord, which was lodged on July 25 against the same petitioner by the deceased, my lord, where there are independent witnesses.
What happened to your writ petition?
No, my lord, I don't have any writ. They have a writ.
Yes, good.
My lords, I am the victim, my lord, brother of the deceased.
I am appearing for state.
So the family is at variance to one another.
Lords,
Wife of the deceased gives a different version, the brother gives a different version.
If your lordships just have a look at, my lords, page 3, paragraph 4 for a minute.
The problem is that which version should we believe at this stage? We can't believe or disbelieve anyone. So we will go by general principles that there is a person against whom the police report says that it's a case of death in a road accident.
No, my lord, it's a suicide.
It's a suicide. Suicide. That's the case.
In his own
suicide. Nothing has been found against him. The wife of the deceased says he is being falsely implicated. You are saying no, he is correctly implicated.
No, my lords, what I'm saying is, with all the respect at my command, the chain of circumstances, my lords, is on 1st of July. This petitioner, my lords, hurls derogatory language on the deceased, on count of which the first FIR 249 is registered there and then. Thereafter, my lords, the deceased, my lords, is abducted. Some videos, my lords, surface where, my lords, he is sitting on the ground and pleading in a hotel room. Whereafter, my lords, he goes, my lords, to gives an affidavit.
What happened to the petition filed by Reva?
It's pending, my lord. And I have, my lord, before my learned friend client is not even a complainant. The brother is not even a complainant. This
I'm
is the
secondly a
complaint
victim.
by the wife, in which, my lord, the FIR registered. I have only 3 submissions to make for your lordship kind consideration. My lord, first of all, there is a little doubt about the commonality of the name, because we are.
The problem with you is that you are an influential politician of the area.
That's what I want to clarify.
No, but that is the possibility of.
One second, if my personal friend.
That gives a possibility of your influencing the.
I'm really grateful to your lordship. But there are 2 Govind Singh Rajputs. I am not the Rajput who's the MLA. He is another who is orchestrating all this.
You are not the.
I am not that MLA. We are, my lord, 150 million, 1.4 billion. We are.
Duplicate of that MLA. Just a minute. If he is not that political person, then why you are after him?
My lords, my learned friend is, my lords,
My learned friend is of your lord. He is, my lord, a disciple of the sitting MLA.
I make a submission.
MLA. I also a sympathizer, member of a political party. I am not an MLA. And Govind Singh Rajput is also the same name as the MLA. He has orchestrated them, this brother. The wife, my lord, the person unfortunately who committed suicide.
Lords, my learned friend is giving
FIR does not even
of
any SCST.
All right, there is something wrong with in terms of, we are saying qualitative wrong in terms of the investigation of this FIR. Any serious objection if you constitute a SIT?
No, I have no objection. One more thing. My lord, just once, my lord, I have no objection, but I want to say something here only to the honorable bench, my lord. The section 18 interpretation which your lordships have carried out to 18 and 18 of SCST, a DSP has to carry out the investigation. My lord, an IO, the IO is an accused against whom allegations have been made. He is the IO, is a sub-inspector. The minimum officer who has to do it.
No, my lords, I have instruction that STOP is conducting the investigation. So far, this part is concerned.
My lords, may I just, my lords, take some clarity. First of all, my lords, petitioner, my lords, is not an MLA. The case is not, my lords, against any MLA. Neither, my lord, victims are MLA. My lords, my learned friend is trying to create a facade. The 2 facts are undeniable, my lord. He is named accused on count of a direct complaint lodged by the deceased.
All right, let us try to solve it.
Yes, please.
Because we want, you should also at least have a satisfaction that there is an investigation which is completely dispassionate, which is free from any kind of local bias, and where you feel that justice has been done by taking it to a logical conclusion, right? That much, otherwise will not express any opinion. Right on.
My lords, may I just, before your lordship, I'm so sorry. Just one point on record is undeniable. On page 3, paragraph 4. From the case diary of the...
We can't observe anything, please appreciate. This is a matter of investigation.
That's correct. I wanted to say a different point. Post-registration of both these FIRs, my lords, this gentleman has, my lords, more than 62 calls with the wife of the deceased. Therefore, there is a direct attempt to influence a family member of the deceased, who is, my lord, subject matter of 2 FIRs, one lodged directly, and, my lords, one post, my lords, committing the suicide.
All right.
First, my lords, very strangely, one common Vakalatnama is filed both by the wife of the deceased and this applicant.
Do you think we are going to mention all these facts in a Supreme Court order, please? put this into mention all these things.
Very well.
Write down the unnatural death of one released Adivasi on 25th July 2025 has led to a registration of FIR number 249 stroke
No, no,
2025.
I'm so sorry, Milords. Not 249. It is Milords 329.
329.
Milords, may kindly
that's-
see the
let
FIR is 329 of
Just a
25.
minute, just a minute. Led to registration of FIR number 329 stroke 2025 under section 108 and 3 in bracket 5 of BNS, read with section 3 in bracket 2 in bracket Roman 5 of the SC/ST Act. The FI date on 4 September 25. On 4 September 2025 at police station
Malthorn.
It
is police station Malthorn.
Malthorn.
Police station so and so.
District Sagar,
It seems that the allegations made by the wife of the deceased are to the effect that Nilesh Adivasi committed suicide on account of the torture and harassment caused to him by a former Home Minister of the state and his associates. There is a long narrative of events made by Riva Adivasi, in bracket wife of the deceased, comma, which is not necessary to be referred to in light of the nature of order which we propose to pass. Suffice to mention that some property documents were allegedly got executed through deception and then complaints etc. were filed by and against the deceased. The wife of the deceased filed her first complaint on 27th July 2025, seeking registration of FIR against the former Home Minister and his associates. But no cognizance thereof was taken. She then filed a second complaint on 3rd August 25 and also approached the High Court through writ petition number 31491 of 2025, seeking registration of FIR and investigation by Central Bureau of Investigation to unearth the factors leading to the unnatural death of her husband. This led to, eventually this led to registration of the subject FIR, that is 329/2025. Next paragraph. The brother of the deceased, what is your name?
Neeraj Adivasi. Neeraj Adivasi. Milords, during
Stepbrother, my lord, not the real.
may I, Milords,
Seems to
stepbrother
have-
will not make a difference.
However, seems to have a different version. However, seems to have a different version.
Milords, my statements were recorded during the inquest proceedings.
All right, we are not referring to. In his very first statement, which is claimed to have been recorded by the police, he has attributed allegations against the petitioner in bracket Govind Singh Rajput.
Of
Bracket close.
Malthon.
Huh?
Of Malthon.
Sir, Malthon is a couple with him. So that is why I say, my lord, Govind Singh, who's the petitioner, because the name is the same. He is the MLA, who's the former Home Minister.
Rajput and some other person being responsible for the unnatural death of his brother. Next paragraph. There are thus two different and contradictory versions coming from the close family members of the deceased with respect to the cause and background of his death. Next paragraph. Unfortunately, the writ petition filed by the wife of the deceased is still pending before the High Court, regardless of, don't say unfortunately, the writ petition so and so is pending before the High Court. Though we have already requested the High Court to dispose of the same via an order dated 1st December 2025, passed in the SLP Criminal Diary number 64256/2025, which was filed by the wife of the deceased.
But the number is now 64256. SLP number has been given. 64256 at page 148 of
Next paragraph. Be that as it may, the question that calls for consideration is whether, be that as it may, what is the facts and circumstances of the case undoubtedly warrant a dispassionate, fair, independent, and impartial investigation into the cause of death of Nilesh Adivasi. It seems to us that the local police has not been able to take the investigation in FIR number 329/2025 to a logical conclusion. The further delay, it goes without saying, will cause prejudice to the prosecution, will be detrimental to the interest of the victim's family, as tendency of investigation might lead to destruction of evidence and or influencing the witnesses whose version is likely to have material bearing on the outcome of the investigation. Next problem. Taking these factors in view and knowing fully well that the hands of the Central Bureau of Investigation, that's the Central Criminal Agency, are already full, and entrustment of investigation to it might cause inordinate delay, inordinate and undesirable delay, we dispose of, we expand the scope of the instant proceeding, we in exercise of our powers under Article 142 of the Constitution, expand the scope of these proceedings and dispose of the same with the following directions. 1I, the petitioner is admitted to, first of all, say the Director General of Police, Madhya Pradesh is directed to constitute a special investigation team comprising 3 police officers. So the head of the investigation SIT shall be an IPS officer, direct recruit IPS officer of Madhya Pradesh cadre, but having no roots in the state of Madhya Pradesh, and preferably in the rank of Senior Superintendent of Police. Don't say preferably, and in the rank of Senior Superintendent of Police. The second member of the SIT will also be a young IPS officer, of any rank, a young IPS officer who should also be belonging to, who should also have his roots other than the state of Madhya Pradesh. The third member may preferably be a woman police officer in the rank of DYSP. The next direction. The Director General of Police shall constitute the SIT within 2 days. Within 2 days, the SIT is directed to take over the complete record of FIR number so and so and all other connected FIR in their custody and immediately commence the investigation. Next paragraph. In light of the different versions which have emerged on the record of this court, we direct that arrest of the petitioner shall remain stayed as an interim measure, subject to his furnishing bail bonds to the satisfaction of the head of the SIT, to the SIT for this one? Bail bond to the satisfaction of the jurisdictional chief judicial magistrate. If the SIT finds any incriminating material of grave nature hinting towards involvement of the petitioner or for that matter any other person, it shall be at liberty to don't say any other person here, and say against the petitioner, the SIT shall be at liberty to seek the leave of this court. Leave of this court for custodial interrogation. Leave of this court for custodial interrogation. Next paragraph. The SIT will look into both the versions that have emerged from the family side of the deceased. However, the SIT will also consider other possibilities that might have led to the unfortunate death of the victim.
Since he did not leave behind any suicide note.
When recovered. Next paragraph. The SIT will immediately ensure that the witnesses, the vulnerable witnesses, especially the widow of the deceased, are not influenced by anyone. The witness protection principles be immediately enforced, and it must be ensured that Reva Adivasi or any other witness is not influenced by anyone. Next paragraph. Similarly, as an interim measure, it is directed that no coercive action shall be taken against the brother of the deceased. What is his name?
Neeraj Adivasi.
So and so, and his family members, so as to enable them to join and cooperate with the investigation as entrusted above, free from any fear or influence. Next paragraph, main paragraph. We expect the SIT to conclude the investigation as early as possible, but preferably within a period of 1 month. Next paragraph. The High Court is requested to take up petition number 3149 of 2025 and dispose of the same in light of the directions issued here and above.
My Lord, may I just suggest the connected FIR, as your lordships have, my lords, dictated, is 249 of 25, dated 1st July 25.
We have said all the connected affairs, including FIR number 249.
249 of 25.
My lords, as state, my lords, there is something important. This is only to apprise my lords that subsequent to this, as I have been told yesterday, there is one more FIR registered against the petitioner by one scheduled tribe lady. Against the petitioner by the one scheduled tribe lady. So, my lord, and there are land grabbing cases, there are revenue cases, etc., etc. But
those are unconnected.
have any
No, we can't. We are not granting
on
any
that.
उसमें देखा ना petition will,
My lords may say that SIT may take care of
in a case that might be
that FIR is of
might have been registered or registered in future in relation to the incident in question. We are only confining this case. If he has committed murder, he has to be the law must take its own course.
I'm not opposing this at all, my lord. I was only apprising my lord that there is one more case registered. So what will be the fate of that? Perhaps because
those will
then that will take its own course. It will also be taken care by the SIT because the same allegation, because the crux of the matter is the land of the deceased was, there was some dispute between the petitioner and the deceased.
No, those all must be investigated by SIT.
Yes, that for my lords. That's what I was.
It goes without saying that SIT will investigate all the related issues, including the genesis of the dispute, alleged motive, genesis of the dispute or motive of the crime or the alleged motive of the crime.
Grateful.
Grateful.
Grateful, my lords.
I'll
go for that.
Wait.
Very.
Prayagraj is not like that.
Wait, please, Manoj. It's 4 cases against me. When I went and filed my application for transfer, the session judge said I can't transfer because this is an MP MLA court. I take it in on appeal saying that please clarify for the High Court whether it can be transferred or not. It's not a because the kind of observations against that, there are 4 matters, my lords. Not against the lawyer.
Now people are becoming so hypersensitive that you start alleging bias against those who come to ground.
This is the.
You ask one question and the people think as if we are doing something. Yeah, absolutely.
I know what your lordships are referring.
I'm going to take very strongly.
No,
I'm not afraid of the things.
We know that because I know what is following from.
Because court makes an observation, you start blaming the people.
This is not court observation. No, this is.
Courts will have to analyze certain things. We create hypothetical situations in court sometimes.
I bow down. But this is not that situation. No, there are observations in the judgment itself.
There is a wrong impression that somebody can browbeat the court.
No, they can't, Manoj, and that is very wrong.
I'm not going to take. I'm a very tough person to be handled.
Absolutely, Manoj. Please do. We also on this side of the bar, we don't support such thing. In the matters which are pending, it shouldn't be there, Manoj. There's nothing.
Now tell us, how do you feel that? What is the bias?
You see the observation. I can show the observation in the High Court. Everything is blamed to me. There are 4 FIRs, my lords. If he's taken a view, he's read the evidence of other FIR in this, my lords. Kindly see this.
So that's good ground for you to go in appeal.
What he went in appeal.
Not a ground for seeking.
As far as kindly
have trust in the system.
Look, it's in the lower court. This is not so. Kindly see 408. When the High Court asked me, my lords, why did I not come in 407 directly? I said I had to go in 408. That's a mandate of 407. But the High Court then says that no, I don't think this is a ground. Please see the observation at page 421 that the lawyer has been delaying the tactics as far as this. Trial concluded, my lords, from January till August. From January it started, and after framing of charge, 30 days.
If I may just support, Lord, if I may just supplement after Mr. Agarwal, Mr. Dave is finished, Lord.
Please consider this, my lord.
That I have to expedite the hearing. He is saying that I have to expedite the hearing.
My lord, may I just say this? Lord, there is a lot that has happened. There are material that has been relied upon, evidence that is not there. You can't look at Google takeouts, Lord. You can't look at beyond the record, Lord.
Siddharth Square, my lord.
Mr. Siddharth and Siddharth.
I send the better Siddharth to your lordship's court, Lord.
I'm going to change my name. I'm going to
both are very good Siddharth for us. There is no better or good. Both are very good Siddharth for us. But please see, if we start transferring cases like this, what is the impact we are going to do?
My lord, may I just point out, may I just say this, Lord? There are 4 cases. In one, there is a conviction. We are really relying on what has gone wrong. The appeal is now admitted, of course. It's coming up for final hearing in that matter. But the challenge is not slightly different. The challenge is the way the lawyer has been castigated at time and again, Lord. He is now so afraid he doesn't even appear in the other matters. Secondly, Lord, can I just show your lordship one page, not 421? Just have a look at this. Just look at 421. Just see, Lord, just see something, Lord. Just see 421.
We give full margin that a mistake might have been committed of reading evidence of A trial into B trial. Let us take it.
My lord, no, something else, not something else. Please see. My lord.
It can happen even with us also. In Supreme Court, it very much happens. One day, about a couple of days back, I corrected one order. There was a factual mistake. It does happen. Sometimes because of you are overburdened with so many heavy paper books, the files, and look at the voluminous record and the evidence.
Can I show you one para, not one para, Lord? If my lord just sees just one para at 431, just read one para, Lord, of the trial court judgment with 431.
Yes.
It seems that the accused was taken aback with respect to framing of charges. Even after that, the case was adjourned for FDT on 3 occasions.
Where are you reading?
It's in volume
431.
28.
Volume 2.
Volume 2, Lord. Volume 2.
Volume
431.
Now, not just see. Just see volume 2, 430. Not it begins at earlier, but 431. Just see this.
431.
Yes. It seems that the accused was taken aback with respect to framing of charges. Not, and even after the case was adjourned for FDT on 3 occasions and subsequently on 19th April, accused sought permission to obtain the assistance of an IT expert to verify the records and also insisted for presence, which was accepted by the court, was directed to jail to produce him. Record indicates that continuously for 3 days the inspection were made by accused, and in the meantime trial was fixed on the previous day, etc. The case was advanced application 207. Now I'm reading this to point out, Lord, this is
128.
absence of fair trial.
From these observations, Mr. Luthra, you don't draw an inference of bias. Please go.
Para
My lord,
128.
the point is the court is proceeded with just the
128. Judge says I should be proceeded for professional misconduct. Please see this, Lord, page 436, 128. The judge holds that I should be proceeded. The lawyer who's conducting the trial, please see at 437. It would definitely, in my humble opinion, last 4 lines.
That he's right in not noticing these facts. If every day counsel are being changed, the court is right in not doing that.
My lord, in fact,
one adjournment, if I ask for an adjournment,
sometimes you know, in dealing with a matter where unfortunately a lot of this media hype have been created, all this, but it's only that he is bringing everything on record.
my lord, my problem is there are 3 more trials there.
Because that he's there, he's the lawyer in the second case, he's the lawyer in the third case, he's the lawyer in the fourth case. Now, Manoj, with this,
it doesn't make.
Manoj, I know that your lordships don't harbor anything, Manoj, but it can be sent to another court, adjoining court for trial, Manoj. The trial judge says that there is no NPMLA court, so therefore a session so that they can't be transferred. But as far as these things are concerned, there is an amount of prejudice, Manoj. Your lordships have held so.
We will help you in rebuilding your confidence in this system. And
but some
have full trust and faith in the officer. We can.
My lord, there is
we also.
There is one request, my lord.
No,
the matter which is listed in another court tomorrow against the same petitioner, my lord. We had unfortunately given a letter for tagging. It could not be tagged. All I'm saying is let it be taken up together, my lord.
All right, we will help you with a few observations, and that will take care of it.
My lord, that is listed in another court.
Lord, that's before another bench.
That's before another bench, my lord.
We are trying to always saying is not that
occasion, my lord would recollect. I took an adjournment on the ground that the other SLP also should be taken up together. We gave a letter, my lord, but unfortunately it could not be tagged. Mistake is mine, my lord. All I'm saying is let it be taken up, both the matters be taken up together and orders may be passed.
You don't know why to unnecessarily.
My lord, may take it up in first week of
never have any suspense or uncertainty about in this kind of things.
My lord, our concern is the certainty, Lord, that we are facing there. That's the reason we have come to your lordship.
The specially petition, the instant specially petition directed against my order of 24 September 25. Passed by the High Court of Karnataka from declining the petitioner's prayer for transfer of the trials pending before one learned presiding judge. Pending before the learned presiding judge of 81st Additional City Civil and Sessions Court, Bengaluru.
The MP-MLA court. It's an MP-MLA.
Comma, in bracket, exclusive special judge for MP/MLA cases. The prayer was to transfer the case to any other sessions court in Bengaluru. Next paragraph. The ground on which the transfer was sought is based upon certain observations made by the learned presiding officer in his judgment dated 1st August 2025, convicting the petitioner under section 376, 276, 354A, 354B, 354C, 506201 IPC, and section 66 capital E IT Act, and section 357 in bracket capital A. What is 357 A CRPC?
Lord, compensation, Lord.
357 days.
Act. Next paragraph. We have produced those governments, those observations made by the learned presiding officer with the able assistance of Sri Siddharth Luthra and Siddharth Dave, learned senior counsels representing the petitioner. So it seems to us that these observations are made innocuously and factual with reference to the record of the particular trial and observations of the High Court. And keeping the observations made by the High Court in previous judgment rendered in the petition number 13645/2025. So be that as it may, these observations by the presiding officer cannot be the foundation of forming a definite opinion of bias or prejudging the issues. Next paragraph. We have no reason to doubt in our mind that the learned presiding officer shall not be swayed by the fact that he found the petitioner guilty in an earlier case, and obviously, he shall evaluate the evidence in the pending trials. He shall evaluate the evidence in the pending trials and will confine his conclusions on the basis of evidence of the evidence led in the pending trials only. In other words, no inference shall be drawn against the petitioner on the basis of the previous conviction or the evidence led in the trial which led to his conviction.
And is under appeal, Lord, and is under appeal.
More so when the appeal by the petitioner is stately pending before the High Court. Also. I think that takes care of everything.
The Lordship may expunge this professional misconduct part.
Professional misconduct issue, not against the law.
The honorable judge observed that I should get this done from the appeal which is pending, my lord. But you're not.
Your appeal is pending there.
There's a
Lord, no, Lord, the appeal of the petitioner is pending, Lord, the lawyer has just been unnecessarily castigated.
All the contentions like expansion of remarks by the presiding officer, can be raised by the petitioner before the High Court in the pending appeal. We request the High Court to consider also submissions in the light of the facts and circumstances and the material on record.
Lord, just one request, Lord, there was that one observation, Lord, against the lawyer at page 437, Lord, that's against the lawyer, not against the litigant. My Lord, may just consider that will impact that young man. It says, in my humble opinion, the aforesaid act would amount to professional misconduct, Lord. That's the only thing we were also requesting, Your Lordship. 437, Lord.
This observation?
This observation, my lord, that it amounts
observation, Lord, against the lawyer, Lord. Arun Ji.
Page 437, bottom, my lords. Last 5. In my humble opinion,
that observation is actually inspired by an observation made by the High Court in the earlier petition.
High Court didn't observe that misconduct. The trial
High Court observed that it was
delaying tactics. That I was
it was a delaying tactics, and that is what again was being indulged.
Once the trial gets concluded, 8 months.
You see, that
3 months, 3 months the trial.
So sometimes they think that because of that they are wearing robe, they can try to.
Your lordships have more experience.
The High Court
talking of Mr. Dave or Srinivasan here. We are not talking of.
Trial court practice, my lord. There's some time.
And that is why the standards of discipline have to be put on a higher pedestal than perhaps the Supreme.
Some claim the
You
joints are.
can't allow the judicial officers to be held at ransom, Mr. Dave.
Joints, my lord.
Absolutely. Play at the joints are very good, but making them disjointed is very dangerous.
He's the lawyer who knows the entire charge.
Sir, what has happened? This lawyer is appearing representing the accused in collateral cases, withdrawing his wakalat in this case. Is this a fair practice?
My lord,
And if
can
the
I
High
just-
Court and the trial court comments on that, we are going to.
He withdrew because, he withdrew because the trial court, he thought that his interest would not be served. But there's nobody knows, there's voluminous evidence. Voluminous.
Mr. Dave, let him tender.
Para 17 plot of the High Court order actually didn't castigate the lawyer, just not. The High Court had left it short of castigating the lawyer. Not the High Court did not, and not that has been read.
You must acknowledge that he indulged in malpractices. It's an absolutely professionally unethical thing which he did. Let him tender apology before the High Court. High Court, we are quite sure will be unanimous.
Can I just point out something, Lord? Just see para 17 of the quoted judgment, Lord. Please see what the observation of the High Court was. All of that was arguments of the internal page 435, but all of those were arguments para 13 to 14 to 16 of the respondent state council. The High Court only said this. Accused and his mother are not common. Submission made on behalf of petitioner that they are finding difficult to engage services cannot be appreciated, more so considering that by engaging services of advocates, this petition was filed.
Mr. Luthra, we don't want to send a message that look here, I went to Supreme Court and I got an order, now you see.
No, Lord, that.
We have to keep the morale of our district judiciary also high.
Lord, all I'm saying is the High Court didn't do it, Lord, and even the earlier.
For the High Court will take care of. Disposed of, don't say disposed of.
My lord, with respect to the connected matter, my lord, there's a connected SLP.
Your matter.
That's tomorrow.
That's listed tomorrow.
SLP लगाया है transfer के लिए.
अभी आज लगा रहे हैं.
Tomorrow for another trial.
It's listed tomorrow, so that will also be taken up so that.
So same order will pass tomorrow, don't worry.
It will have to be withdrawn from
The other bench, Lord. It's in the other bench. It's gone to the other bench.
No. Is it listed tomorrow where?
Yes, it's listed in the final list.
Before us only?
No, my lord.
No, my lord.
Another bench.
My lord, it happens, my lord. I am to be blamed, my lord, not anybody else. I am to be blamed, my lord. I gave a letter, I did not follow it up. I am to be blamed, my lord, not anybody.
No, it's okay. We informed the registry.
That is what, my lord.
No. Then you produce this order before the honorable bench.
I will do that.
But it may be uploaded to them.
Today.
Or they may withdraw the transfer. Or give the matter which is coming up tomorrow.
SLP's criminal 19003 of 2025.
Just note down and
Code 3, item 35.
In any case, we will release this order. You will have a copy of this order available with you. And let us see. Give us the number, we will take care of it.
Great.
To start the SIR matter now. Petition side, is it over or anyone left?
Bengal and Tamil Nadu.
May I point out? Yeah, mention it. No? Your Lordship, may I point out, on the last occasion, Mr. Ramchandran had to start today. However, the Tamil Nadu batch of matters is not listed today. Therefore, may I propose that those files also be called? I think that might have been a mistake. But Mr. Ramchandran is coming from court 13. He's on his legs. They're coming. Any moment he'll be here. May I request that the files be called for the Tamil Nadu batch of matters? This is writ petition.
Matter will do about it. Tamil Nadu matter is which date? So we have fixed now, we have segregated the cases statewide. The Tamil Nadu matter will be on 17th. But Mr. Raju wanted to assist us on general principles of SIR. Let him come argue today, and if we need additional time for especially the Tamil Nadu matter, we will again hear him. There is no difficulty in that.
But that is a different notification altogether.
We are aware of this fact.
In fact, he was instructed in that matter, and yes, your Lordship had indicated that
issues are common. There is a lot of commonality. There are overlapping issues.
That's right.
So instead of now hearing in piecemeal, we are hearing all of you one by one.
Very well, very well. May I then propose that I begin whenever when he's coming from that thing.
That West Bengal matter, your Lordship have adjourned it to 17th, but that's connected with this.
Mr. Sibal, we have varied that order. Now what we are doing is that today is 11th. So all behalf.
That's best because that's the best way to do it.
To on the statewide issues also, but we will just want to complete your submissions on the broader principles, but of course the Bihar factual issue also, because that is concluded. Mr. Raju Ramchandran has nothing to do with the Bihar matter.
That's right.
Whichever way Lordships deem appropriate.
Otherwise, Mr. Dwivedi, these matters, the other thing, we are now informing, I'm directing the registry not to entertain any press.
That's correct. That's correct.
This is absolutely now becoming unmanageable affair. The matter is going on. Litigants are coming. Most of them are now coming only to get popularity. We are sorry to say. Matter has been argued very seriously. All of you have rendered excellent assistance to us. And we don't think that now fresh matters are required.
No, I agree entirely, Manoj. I think that's a good direction. The Lordship should pass it.
Whosoever wants to, of course, members of the bar are most welcome, even if they don't have any matter already filed. And if they want to intervene and assist us, we are always open to them. They can give their viewpoint and will definitely take into consideration.
So let my learned friend start and then we'll respond on the 17th, Manoj.
We just thought, where is Mr. Raju?
Mr. Ramchandran is coming. He's on his way, Your Lordship. He's there coming from 13 now. He's on his legs in 13. He's just coming here. He's just coming.
We kept for him only, otherwise we were winding up from...
Right. No, I'm aware.
Start, why don't you start?
I'll begin showing the impugned order in the Tamil Nadu case. It's important to show because even for all the other states, they are relying on the 24th June notification saying that when we complain saying that there are no reasons attached to all of these.
Tell us Mr. Ramchandran wants to argue on general principles or...
Yeah, general principles.
Or only with respect to Tamil Nadu?
There is certain things that he does want to show in respect of Tamil Nadu order and all the other state orders as well. But the arguments are broader principles are what is going to be advanced. That is what you can prepare. Because that is what your lordships had also indicated the day before yesterday when the matters
we will take up on 17th. Now we have notified this schedule because otherwise it will create problem for us.
May I just hand over the note?
Anyone in the Bihar or Bihar related matters, if anything left out and from the petitioner side, if you want to make any submissions, you can do so.
May I hand over this note that we had?
This note is for what?
No, this is the note that Mr. Ramchandran had to rely on while arguing.
So then you start reading this note. Let us see what Mr. Ramchandran says.
That is right. That's right.
Before my learned friend starts, may I mention serial number 9, my lord? It's that temple theft case, man. So it's the very next matter, my lord.
That matter, I think we will not be able to take up today. This SIR matter.
Yes, no, my lord, I'm not asking for any indulgence in that sense. If this is a part-heard matter and it's a more important constitutional matter. Except my client is also not 73 years old and a senior citizen. And all of we have followed your lordship from courtroom number 4 to this court on that matter. But most of the hearing has been heard by this bench, my lord, in the last 3 hearings.
No, that we will not allow it go in waste.
Right, I'm obliged, but that's all.
Time next week.
Is it miscellaneous next week? I don't know. It's not declared. Not declared.
Not yet, but they're going to make it the fine hearing. He said so in court.
Do you want them, because he asks me as the legal counsel to keep whatever is needed ready. Do you need that? I need them.
In January. Because we are hearing some other matter, which is on day-to-day basis, we are hearing from the last so many days. And we don't want their arguments to be forgotten with your articulation and the eloquent knowledge which you are having on the religious issues. We would like to hear you with lot of patience and with cool mind after getting...
I have the patience, Lordship, no issues.
So you will have to again come in January also.
No issues.
We'll notify a date, Mr. gentleman.
Lordship can give a date, it will be helpful for me to book the tickets a little bit cheaper for me. Even yesterday, I had to cancel my Indigo ticket and then I had to come with 20,000 rupees on the way, all the way from.
Take the mic with you.
So if there is a date, it will be helpful for me to book the tickets at least.
All right, we'll take care of the next date, then we'll hear you.
These other matters might get over the side of the vacation. So that you, the certain matters which your lordships are hearing, if it gets over the side of the vacation, lordship may give us a date. First or second week of Jan. Petition.
You must have heard it. The SIR matters are till 18th December. So what is left then on this side?
Therefore, if your lordship require all the states in the other matters of SIR also to argue on the principal question of.
No, it will not be. We are 100% sure SIR is not being concluded this side of the year. Because petitioner side is also not very keen. Meanwhile, some fresh petition will come. Of course, we are now stopping.
So if the only thing is not that if I start this, then on Tuesday there will be a break because then that UP matter and Tamil Nadu matter.
No, but that one matter is over now. That because of that we are breaking the bench. That Army and Air Force and Navy.
No, not that. I'm saying that if I begin the argument today, my lords, so I will take, my lord, at least 2-3 days, my lord, then my learned friend will take, my lord, there is a huge expanse of argument, legal aspects which have to be dealt with. Then on Tuesday and Wednesday, your lordship will take up Tamil Nadu and other matters also, Lord, then it will be a break in my argument. Lord.
This matter we will not stop you taking 2 days because we have granted them couple of days.
Yes, ma'am.
But from January, I am issuing an order. This is my humble request to the members of the bar to cooperate. In every case, you will have to give a timeline within which you will argue the case.
That's right.
What is happening in this case and it is very absolutely unfair and unjust. And in court, sitting here, I don't want to permit it. What is happening is that in some of the matters which are perceived to be very important, the entire court time is taken. Some poor fellow who is fighting for MSCT claim, who is fighting for bail, who is fighting for small injunction issues, they remain sitting on the last row. And in the evening, 4 o'clock, they leave the court, disappointed, not knowing when their matters will be heard. So I want an equitable distribution and proportionate allocation of court time to all the cases. Yes. And that will happen only when you give in writing a commitment to me that you are going to take, not only me, to the every bench, that you will take this much time to argue. So that the bench is in a position to determine, to fix its own roster management. And then they can allocate the date accordingly.
My lord, see, so therefore, my lord, I am whether your lordships recall, there was a session held, my lord, some time back, and under the auspices of Justice Nagaratna, as to how, my lord, it could be expedited. There were inputs from several. Why I say so, my lord, because I was also there. One suggestion which came forth, and that is part of the report which has come from Chief Justices. In all such cases, my lord, there could be mandated written submissions, my lord, which are circulated, vetted, settled by the senior who is appearing, the senior is appearing, and my lord, then circulated well before the matter is taken up for hearing. And at that time, my lord, the bench will get an undertaking, just as your lordships indicated, from the counsel who is arguing. So this will take half an hour, this will take 45 minutes. If they say we'll take 2 hours, your lordships could always intervene and say, no, we will not permit you more than half an hour, 45 minutes. Which case, my lord, what happens is, generally, 3, 4, 5 matters, final hearing matters, my lord, could be taken up on Wednesdays, Thursdays, and it will necessarily be taken up.
There's an
one thing which might, my lord, cause a difficulty for the bar could be, where your lordships make it clear that if it is therefore listed on a particular day, and therefore, my lord, the time has been settled, an adjournment will not be permitted under any circumstance.
So that also, adjournment also, we are restricting no adjournment in the matter for final disposal or regular matter. that also we are introducing it. This will have to be, because unless and probably the bar is more keen than us to introduce these reforms, very small procedural reforms. But what I find is that bar seem to be more responsive and more keen that we should introduce it, because that is the way only we can give some time to the ordinary litigants also, that their voice is heard.
Correct.
Look at that Fauzi here. You are there in that railway accident matter. So, yesterday night when I was reading the file, the man died on the railway track. The railway tribunal probably rejected the claim or whatever happened. Then we allow that claim.
And after 23 years, she's been able to get that money with us.
Now, we granted some compensation to the widow, to the children also. Their whereabouts were not known. Look at the poor persons, after losing faith in the system, they disappeared. Then we had to direct with it. It's all because of the young lady lawyer that pro bono rendering services, that we have been able to trace out that family somewhere. They had no bank account, there was nothing. Now their bank accounts is open, 8 lakh something, 9 lakh, some amount has been transferred. The smile that widow must have got on that day, that is what I want to earn in life.
That's right.
Nothing is required.
That's right.
So therefore, some time we will devote for these cases.
That's right.
And this is the message which must go, and for that we will expect the bar also to cooperate with us.
Of course.
So timeline part also will introduce.
Once your lot.
Finally, Mr. Raju Ramchandran, you are here. So you know that you are busy, you are on legs.
My lord, so if it commends to your lordship, my lords, if lordship approve, my lords, let the other side finish today, my lords, and give me, my lords, Tuesday, Wednesday, Thursday. Rest of the specific things can be taken in January.
So now Mr. Ramchandran is starting. So let us see how much time he takes. Then depending upon how much will be left. Your matter, Mr. Jetblani, and your matter will take up in January.
Right.
But we can assure you the time investment which you have made in this case. It will earn some. It will earn some.
I have no doubt about that. I am deeply grateful.
There are 3 or 4 matters. Mr. Jitmalani appears in the
The
first.
tag matter, the group matter.
Once, my lord, that first matter is heard, then the other matters may not take up the same kind of time.
New iPad you take out.
I think the lengthy matters which require a lot of time will not be able to take up today, with this matter being there. Some small matters, if the time is left, will surely take up before we start hearing Mr. Dwivedi.
Great.
Right.
So we'll see that you can start the next week.
Next week.
Let us see that how much time they will take and then how much time we are left with.
Lordship are discharging the vote for the other miscellaneous matter. Because this is.
Like some matters we will, or Mr. Ramchandran, are you free now for it?
Yes, Manoj.
That can we take up some small
2
matters?
minutes.
Because that will give us free time.
Lordship, please. We can start at 2 if your lordships. In the meantime, can they call for minutes? Lordship, I'll be here.
These 20 minutes we will dispose of some small matters.
Lordship, I'm grateful for accommodating me.
There any dates, Lordship? Any dates, Lordships given? No?
In the meantime, minutes, may the Tamil Nadu petition file be called, because it is not shown in the list, since I'll be referring to that paper book. Lordship, please, minute. But nevertheless, the paper book may be here, but we'll only give the reference of the
What we
SLP.
have done, Mr. Ramchandran, you were not here, that the yesterday judicial order, which I will upload it today, we have allocated Tamil Nadu and Puducherry on 17th December.
Lordship, please, minute.
17th. So on facts, we will hear you with reference to specific facts of Tamil Nadu. We will hear you on 17th.
Lordship, please.
But today you can argue on the general principle.
Show the impugn order. We'll show from the impugn order.
We'll give you 2 opportunities.
Yes, and we'll conclude today. We'll conclude.
Sorry to trouble Lordships. Is there any dates, Lordships? Here.
The number 1 and number 2.
We will give a date. We can put it. 28th January. 28th January.
January. Oblige, Lordship.
Yes, item 18.
In fact, on the last occasion, my lord had issued notices to the Registrar General of the High Courts, my lords,
I appear for J&K High Court, my lords. The High Court has directly, because there are 5 pending cases. This is the acid attack case, my lords. 5 pending cases, my lords. We have filed a compliance report indicating out of...
This is only to sensitize.
That's
That's
right,
all. Right.
Nobody else was...
When the petitioner appears in person, he has been rendering a commendable service, assistance to us. Where is he? They don't know what is happening. Because we want to know some facts about our own case. We'll take up after some time. Please help us.
Right on, it's started.
Item 10, Vimal Kumar.
Madam, for the respond.
Password in this matter.
Your state, you have to reply.
No, the counter is filed in the matter. I'm praying for a short passover in the matter.
Short accommodation. You are for whom?
Passover. I appear for the state on behalf of the state.
You are appearing for the state. You can argue. You have filed your counter also.
Sir, we filed a counter in the matter.
We have also not received counter. Anyway, we serve us. Just take this.
Complainant. Who is for the?
I am for the respondent number 2 complainant. We have not also received the.
You are the person who invoked 156.3.
Yes, Madam.
What kind of false story you have brought and you are harassing the person whom you have...
Complaints, clearly I mentioned the facts. On the same date I approached police station, they have not done anything. Thereafter I approached SP. Then after applying all the procedures, then I approached before the learned trial court.
Are they facing trial now?
Your Lordship, for the first time, as per their averment, on 5th of July, they approached after around 20-25 days.
Are they facing trial or not under 302? We are asking a question.
After 302 was invoked, after the death of...
God, what happened in that trial against them? What happened against you?
302, my lord, was invoked immediately after 3-4 days. Initially, the FIR was under 307.
Mr. Consul, we are aware of that part, please. We have done our homework. What happened to trial of 302? We are asking you. Against them.
That is there, my lord.
It is still going on. Well, the answer should be the trial is going on.
Yes, it is.
So you are facing your trial. Lead your defense, whatever you want to lead there.
There is case and counter case, nothing else matter is there. So learned judge will proceed with both the cases. And the detailed procedure is there.
Yes. 6-3 complaint. Were you heard?
My lord, the position as of now, my lord, is...
Mr. Consul, if you are not prepared, then we can't do anything. I don't impose your solutions or thing. In the 156.3 complaint, which they filed against you,
yes,
and the magistrate ordered FIR against you, did the magistrate hear you?
No, my lord. In 156.3, the FIR was not registered.
In
the region, the proposed
magistrate passed this order.
Not issued to the proposed accused.
Kindly see the order dated order at
Right down.
57.
Leave granted. The Syria as complainant and wife of Jugal Kishore lodged FIR number 134/2023 at police station Girwan under section 506, 504, 323 and 307 IPC against respondent 2 and her family members. The allegations were that they hit Jugal Kishore on the head with a banka in bracket sharp edged heavy knife. When petitioners number 2 and 3 tried to intervene to help the deceased, they were also attacked with sticks. The occurrence took place on 18th June 2023. All the accused persons were arrested on 22nd June 2003. On 25th June 2023, Jugal Kishore unfortunately succumbed to his injuries. This led to invoking Section 302 IPC also. The accused persons are thus facing trial, which is still pending. The Section 307 was accordingly replaced with Section 302 of the IPC, and charge sheet was filed on 23rd August 2023. The accused are facing trial in that case. Next one. After a long gap of more than 1 year,
Lord, kindly see
if we commit any factual mistake, sir, you are most welcome to correct us. But we can challenge, neither he is prepared, you must be well prepared. They are definitely not prepared, but wait for the fact.
I approach police on the same date. Thereafter, I approach.
You are saying that is what you are saying.
Lord, that is mentioned in the High Court's order also.
That is on 21st September 2024, a judicial magistrate passed an order in a complaint lodged by respondent 2, in a complaint filed by respondent 2 under Section 156 in bracket 3 CRPC, and directed against the registration of FIR against the petitioners, namely family members of the deceased victim. This led to a registration of FIR number 281/2024 against them on 27th September 2024 in the same police station under Section 147, 323, 504, and 506 of IPC. In the second FIR also, the charge sheet was filed on 13 November 2024. The petitioners were then summoned on 18th, wide order dated 18th December, against which they sought 2024. The agreed petitioners approached the High Court for quashing of the charge sheet and the above stated criminal proceedings, but their petition has been dismissed by the High Court, while impugned order dated 2nd April 2025. Next paragraph. It is not necessary for us to comment or express any opinion in relation to the delay on the part of the accused party in filing complaint under Section 156 in bracket 3 CRPC. All that we strongly disapprove is that in such a case, the judicial magistrate ought not to have mechanically ordered registration of FIR without even giving notice to, without a preliminary inquiry, that without holding a preliminary inquiry. No such exercise has been undertaken in this case. Consequently, we allow this petition, FIR number 281/2024.
281.
Huh? 281 stroke 2024, dated 27th September 2024, registered at police station Girwan, and all the proceedings arising therefrom, including the charge sheet or the summoning order, are hereby quashed. Next paragraph. The application filed by respondent 2 under section 156(3) is directed to be transferred to the Sessions Court, where the trial against respondent 2 and her family members is pending. The second respondent or her family members will be at liberty to make out a case. Use the material, including use the material, if any, to probabilize their defense plea. Next paragraph. The Sessions Court shall consider the counter allegation made by respondent 2 or her family members, uninfluenced of the observations made herein above, and such allegations shall be considered as per their own merit.
Right.
Please look.
Last affidavit we filed on this is 2019. I'll just show you. Exactly.
My lords, this is coming after a long time. Our last, my lords, your lordships had implemented Union of India in 2017, my lords, and our last affidavit is actually also filed in April 2017.
Well, in the agriculture field,
Yes, my lords.
there are some very good alternates which are being explored from time to time. That what can be an effective substitute of urea.
Yes, my lords.
I mean, this is one issue. That's one of the issues that non-availability and leading to so much distress among the farmers and compelling some of them to the extreme situations, which are very unfortunate, most unfortunate thing that can happen with a poor person. But are we not exploring something very good alternates which are, in a way lead to healthy product? At the same time, in terms of quantity also the farmer does not compromise. In terms of cost also the farmer does not compromise. And that can be ideally that if the cost effectivity is there, it's a good alternate and it becomes readily available as a substitute. Because the way people are talking, we are not of course expert, but whatever we have been reading and all of you must also be, that urea has also its own adverse impact, as people say, on the ultimately outcome. So maybe some good substitute that is within the country and availability.
My lords, I do have a note on the instructions, but if your lordships will permit, I will place all of this in our record.
That's it.
Because our last affidavit was in 2017.
And there might be some other issues also.
Yes, my lords.
It's not this solitary factor, it can't be.
Please, my lord. So I will place comprehensive affidavit on what are the initiatives covering various sectors in the farming area, my lord.
And how do we incentivize also?
Yes, my lord.
Because that's also extremely important. That whatever we think of as a substitute, that how we make it sure that it is readily available, and how we also sensitize and educate the farmer community that this substitution is better than the earlier one, and therefore it is worth trying.
Please, my lords.
I know some of the farmers who go for pure natural. No, they don't use the word organic also, like yes, because this is also sometimes it becomes
in fact, the country
in regard to the last order, my lord, with regard to Prime Minister Fasal Bima Yojana, my lord, it is a complete failure, my lord. And what has happened, my lord, I have just collected the data from the government.
Why don't you collect? No. Why don't you? We are suggesting
more than 10 states have drawn from Pradhan Mantri Fasal Bima Yojana, my lord. More than 10 states, including the state of Gujarat also, my lord.
You are from now Gujarat.
No, my lord. I'm the intervener, my lord.
Okay.
In person.
No, but the concern is of originating from Gujarat.
Yes, my lord. Right? I would like to draw the attention of this court, my lord, about the order of Gujarat High Court, my lord.
They not the
claim of 2017, my lord, till August this year, The claim was not paid by the state-owned insurance company, SBI Insurance, my lord. And on 8th of August this year, my lord, the Honorable Gujarat High Court directed the state government and the SBI Insurance to pay the compensation or the claims of the farmer.
We are on a different issue, sir. You are arguing something else. We are telling you something else. You are arguing completely different thing. Now that you are raking up the issue of Gujarat, we will only suggest you go visit some agricultural areas of Gujarat, and you find some change there. Change only because of some a very good campaign undertaken by some people who have a vision that how to get rid of the urea and how to go for natural crops.
The petitioner.
Lord's petitioner has basically.
Here, don't
Lords,
start arguing piecemeal. Bring everything on record.
Order dated 2017.
My lords will permit me
I would like to mention, my lord.
My lords may permit me to file a comprehensive affidavit, my lords.
So just, I would like to mention two facts, my lord.
Please, no, nothing in piecemeal. If you don't know the farming and don't know about the farmer, then don't argue also.
I have done.
The learned Additional Solicitor of India seeks and granted 4 weeks time to place on record the comprehensive initiatives, a comprehensive details of the initiatives taken for by the union or the state governments, or other stakeholders to address the various causes that invariably lead to the distressing situations for the farming community, for the farmers on pan-India basis. The petitioners are also the petitioners are also permitted to place on record their suggestions and the information which they have gathered from different parts of the country. Do the needful and then we'll hear it.
Please, my lord.
Item 20. Through last order in July 2017, my lord, that this honorable court directed for a meeting of all the state governments, my lord. But the meeting has not been done till today, my lord. In that regard, on the last order of 6th July 2017, my lord, this honorable court directed for meeting of all the stakeholders, including all the state governments. But the meeting was not held ever, my lord.
We'll see.
Item 21 relates to appointment as to the Superior Judicial Service in Chennai. It's a 2023.
Superior Judicial Service in?
Chennai, Madras. It's a 2023 process, my lord. He had the highest score, but he's 2.5 marks less from the cutoff. So if your lordship can consider it on any day after lunch, your lordship is probably
below cutoff. He was not notice issued.
I am in 21.1. I have nothing to do with 20. 20 raises a larger issue. I have a much narrower issue.
The only thing is, Mr. Pudwalia, we can only, who is representing the High Court? Are you there for the High Court?
Your lordship may keep it on some other day, because after lunch, probably your lordship is taking up those SIR issues.
But that would be, I think we should leave it to the High Court. Say, though the High Court has filed the counter affidavit through its Registrar General, or we would still impress upon the High Court. However, it seems to us that the High Court may, if it is found to be in the interest of the judicial services, without compromising with the standards of minimum benchmark, consider the desirability of some relaxation that may enable the High Court to fill up, if not all, from a substantial part of the vacancies falling under clause 6, capital B, Roman 6.
Correct. I'll
falling in the category of, this was direct recruitment.
This is, yes, direct recruitment.
don't, vacancies which fall within the direct recruitment quota.
Correct.
So we however leave such a decision to the entire discretion of the High Court. The decision that may be taken by the High Court may be placed on the court. Post the matter on considered.
Grateful. Very good.
We are coming back, sir. We are sitting after lunch also.
Just one thing, my lord. But 102, my lord, slightly long match. My lord, give me a specific date or month, my lord. 102, my lord.
Regular matter 102.
My lord, give me January or my lord, February.
See when to be taken.
Grateful.
Also mentioned. More.
My Lord, with your kind permission, I want to mention yesterday order of Bar Council Women Elections.
There is mistake, my lord.
Para 4 of the order, my Lord. Para 4 of the order. We note that the elections for the 4 bar councils has already been notified. Whereas for Telangana, I have a schedule of the 20th December, the notification is to be released, my Lord. It is not yet for Telangana. I need to file seeking a modification of the order.
Who say if Telangana is excluded, then who are the 4 states?
I don't know, madam. Whereas for Telangana, I have submitted the schedule of the
Please, this is the schedule.
schedule, my lord. 20th December is the gadget notification. And at present, 25.
Why have we included it? Because we have used the word have already been notified.
Notify is on 20th December, my lord. And in the present elections, 25 women, none have been elected.
We have used the word election of 4 bar councils have been notified.
Yes, my lord.
And this notification of Telangana is 25th November 25.
No, my lord. Here, election notification gadget, serial number 4. It is.
No, that's right. But election is already notified.
No, the schedule has been declared, and even after that, the notice has been issued by my lord, and to be listed on 19th, and mail has been given. My lord, last 5 years.
Litigation.
No, present body more than 8 years they are doing, my lord, and all 25 members are women, men, and no women could able to win the elections. So, is the opportunity can be given because of.
Let's not now do anything. We'll see next time.
My lord, petition is to be filed.
Permission, may I mention item 13? 13 is a contempt petition. On behalf of the state, I'm seeking today's.
First, you take the mic, please, and then.
I'm so sorry, Malad.
We thought that this mentioning business is now stopped.
I'm so sorry, Malad. Malad, I'm for the state, Malad. In 13, it's a contempt petition, Malad. Malad, there are some employees who are seeking, Malad, and contempt for an order that has been passed by your lordships. Malad, my counter affidavit is ready. It's not on record, Malad. I'm only seeking a week's accommodation, Malad. I've already notified the petitioners also.
You want to circulate your counter affidavit?
Well, it's just a week's time to bring it on record, Malad.
No. You have filed counter affidavit, or you want time for?
Yes, Malad. I'm praying for time to file, Malad.
When the matter is listed?
Today, Malad. Item 13.
All right, grant time.
Well, I appear. Your lordship, I appear for the High Court in this matter.
Mention, my lord. It's a joint request, my lord. It's only a joint request, my lords. Item number 10222, my lords. Any date, my lords, in January, confirmed.
102 is a regular matter.
It's regular.
Regular matter will continue on the list. If it is not taken today,
yes,
then automatically it goes for next Wednesday. Please try to understand. See the list of how we have structured the list now. You are not required to make mention. Everything will be automatic. Any regular matter which is not taken up on Wednesday, Thursday, will automatically go next Wednesday unless you make a request for a longer date.
No, we are making a request for a longer date.
You are making a request for what? Not a longer date.
Yes, my lord.
Why?
No, my lord. It's a long thing, my lord.
If you don't list, then early hearings are there. If you list the matter, then you want a date. When the matter is taken up, then we will see.
Your lordships.
Your lordship, may I mention
some accommodation. Great.
Well, it's in that item 13. I appear for the High Court. My affidavit is on record. In item 13, which my learned friend mentioned just now, I appear for the High Court. He is for the state.
The state.
My affidavit for the High Court is on record. There is no contempt because the petitioners say.
ये item जो अभी दिया था ये भी लंच के बाद इसकी बुद्धि खराब हो गई थी
I represent the High Court of Karnataka.
Why you are filing contempt? Who is filing contempt?
We have
You are a High Court employee.
we have filed a contempt for the employment of the fast track employees, my lord. As per the order,
You are for the High Court.
I'm for the High Court, my lords. That order, my learned friend is saying, which has been violated, was passed on an application filed by the state of Mizoram. I filed that application also along with my counter affidavit. IN number 36 was filed by state of Mizoram, and
No, but where the question of contempt, their claim has been rejected.
that's what we are saying, my lords. That's the submission.
Their claim has been rejected.
Yes, full court has taken a decision. They have filed writ petitions in the High Court, writ appeals in the High Court. Now today, arraigning the Registrar General of the High Court of Karnataka, the Law Secretary to the State of Karnataka as contemnors, they have filed this contempt.
And the order pertains to state of Mizoram. It does not pertain to the
State of Karnataka.
File your counter. You have filed the counter.
I have filed for the High Court.
You also filed. You are for the state.
Well, I am for the state. I'll file.
Like 2 weeks time to file the counter. We should post it on phone.
Great.
How do you have this file? This kind of privilege litigation.
Gratefully.
Your Lordships, with your kind permission, may I mention a matter? Your Lordships,
May I mention a matter for an urgent thing tomorrow? Your Lordship, there's an urgency in the matter. This is a fresh SLP. All the defects are report. However, it's in the verification stage. But the execution.
What are you mentioning? Because you people don't see any time. Anytime you stand up and start mentioning. What is he mentioning, madam?
Your Lordship, for urgent listing of a fresh SLP tomorrow. There is the difficulty is, Your Lordship, that the execution proceeding is listed tomorrow. There is an arbitration.
Execution proceedings are listed tomorrow. When did you file the matter?
Your Lordship, it was filed last month. The defects were marked. It has been cured, but it is at the stage of verification. And urgency letter was also moved. It was rejected because.
All right, thank you very much. Thank you. When did you cure the defects?
Yesterday, Your Lordship, all the defects were.
Yesterday.
Yes.
2 days time is to be required. What does my order say? The date you cure the defect will take 2 days to list your matter. Monday your matter will be listed. You don't require any mentioning.
I bow down, Your Lordship. It was just the difficulty is that we got instructions that the execution.
What we can't solve every difficulty. We don't have that magic wand. Wait for Monday.
Your Lordships, may
If Monday it is not listed, you mention.
All right, Your Lordship. Thank you.
Your Lordships, with your kind permission, may I mention a matter? Your Lordships, this is a tender matter. The matter was listed on 1st of December when Your Lordships were pleased to issue notice and issued an interim order.
From Monday, then I will issue another note telling that if there is a mentioning and which I don't find genuine, I will impose cost then and there. A circular may be issued. Not less than 50,000 crore. And we'll create a corpus for the young lawyer. Write down a judicial order, suo motu लिखने को आज ही कर देते हैं हम लोग. We propose to create a corpus for the welfare for the professional strengthening and for the training of the young entrants in the legal profession. For the purpose of creating this corpus, one of the sources to generate funds is to impose costs on frivolous mentioning. So the members of the bar are requested and well advised. कर दे order पूरा. चलो छोड़िए. Yeah, what is your mentioning of?
Your Lordship, Your Lordships had issued interim orders in the matter and specifically directed the matter to be listed on 12th. However, Your Lordship, the matter is not present in the cause list for 12th. Lordships may kindly have it on 12th.
Find out first of all, Grant. Have you gone there?
Yes, Your Lordship, I have been to the listing department as well as the judicial registrar for listing.
There is a stay in your favor. What is your problem?
Lordships,
if there is a stay in your favor.
Lordship, there is no stay. Your Lordships are directed that the final outcome of the tender process will depend on the outcome of the proceeding.
Then there is an entire order protecting your interest. You'll see, go to and give your detail to the registrar. Yes, item 18, we'll like to hear this well. You are also there.
Yes.
You can also assist. Please come to the mic.
Because on the last date, learned Solicitor General had said he would be seeking instructions on this. The petition which we had filed. So we are waiting the directions, if any.
Take mic and
Yes, Milord.
you are
I'm
here
appearing
to
for the
defend. You are here to defend a very most one of the most genuine cause.
Yes.
So therefore, your voice must be having the same strength as you need to defend this kind of issue.
Sure, Milord.
Why are you stressed and afraid of?
No, Milord, I'm not at all stressed. So, Milord, on the last date of hearing, the learned Solicitor General had mentioned that he would be taking instructions regarding the PL which has been filed. And
Now,
so we are awaiting.
tell me 2-3 questions. This Shaheen is also here.
Yes.
What happened to this juvenile?
जुवेनाइल सर जुवेनाइल का कन्विक्शन हो गया था 2015 में
अभी क्या पोजीशन है उसका?
सर उसको ऑब्जर्वेशन होम में रखा गया था 3 साल उसके बाद तो फिर वो वहां से रिहा हो गया था जो एडल्ट केस है वो अभी रोहिणी में चल रहा है सर
वो तो मैंने देख लिया उसको कितनी एज का था जुवेनाइल?
सर जिस टाइम क्राइम किया था ही वाज 16 और 16 एंड हाफ और जिस टाइम पर वो 2015 में कन्विक्शन हुआ है तो वो एडल्ट था मतलब उस टाइम पर वो हो चुका था 24-25 का
और उसको कंटेस्ट किया था किसी ने जुवेनाइल है या नहीं है? कोई एविडेंस हुआ उसमें?
सर कंटेस्ट नहीं किया था उस टाइम पर कोई इतना सपोर्ट नहीं था मुझे कुछ नहीं था तो पता भी नहीं थी चीजें बहुत सारी हमें सर
जो बाकी अक्यूज्ड हैं ये क्या उसके दोस्त हैं उसके परिवार के हैं?
हाँ जी सर जो जेजेबी वाला जो था उसके कजन है और जो कजन है वो वहां पर जहां पर ये अटैक हुआ वहां पर वो मतलब एम्प्लॉय था वहां पर पढ़ता भी था काम भी करता था तो मतलब एक दूसरे से सब लिंक्ड है इवन सर मैं जुवेनाइल को नहीं जानती थी डायरेक्टली वो जब मैंने आइडेंटिफाई किया यही लड़का है तो फिर वो चेन एक बनी
अभी जो आया है स्टेटस वो आपकी तरफ से शायद आए हैं तक
जी
क्योंकि सभी ट्रायल कंप्लीट हो गया है आर्गुमेंट्स पे है
आर्गुमेंट स्टेज पे है सर
तो मैडम अर्चना we will not make any observation
I get that.
it should not cause any prejudice to anyone but who is for the Delhi High Court somebody was appearing there was a counsel for Delhi High Court before lunch
It's not in the.
Let's JNK, I appeared pre-lunch.
Plus, the matter is listed on 3 dates now continuously for final arguments.
What is the date now?
Amal is the 12th, 13th and 15th of December for final arguments.
That is tomorrow, day after tomorrow and on Monday.
Likely to be concluded as well because part arguments have already been heard.
Please sensitize your prosecutor that they should not want that they से देंगे जो उनकी फीस होगी हम दिलवाएंगे यहाँ से
सर अभी तो मुझे लगता है कि जो लॉयर हैं वो अच्छे से दे
ठीक है वो आपको इंटरेस्ट एडुकेटली प्रोटेक्ट कर लेंगे
यस यस
प्रोसिक्यूटर बहुत अच्छे होंगे गवर्नमेंट की साइड से वो भी करेंगे आपका अपना लॉयर है वो अपना डिफेंड करे अगर आपको कोई लगे तो आप बताइएगा हम लीगल सर्विस अथॉरिटी से आपको प्रोवाइड करेंगे
ठीक है।
Yeah, we can also, my lord, you can, ma'am, you can tell her or me, whoever, everything will be taken care of.
यस सर बस एक चीज मैं बोल रही थी कि जैसे मेरे केस में जो फर्स्ट आईओ थे तो उन्होंने मेरे सब सीज किए थे कपड़े सब कुछ और उन्होंने अपनी क्रॉस में बोला ऑन द डायरेक्शन ऑफ द एसएचओ मैंने ये नहीं भेजे आगे एफएसएल में। तो इस तरह के पुलिस ऑफिसर्स के खिलाफ सर कुछ इंक्वायरी होनी चाहिए।
अभी आज हम कुछ नहीं बोलेंगे ये आर्गुमेंट क्योंकि आपके वकील साहबान वहां करेंगे।
जी
ये ट्रायल कोर्ट को करेंगे। कोर्ट के पास पूरी पावर होती है। अगर उनको लगे कि इसमें कोई किसी किस्म का नेग्लिजेंस या कोलिजन या कनाइवेंस या डिलीशन ऑफ ड्यूटी कुछ भी हुआ है तो उसके प्रोपोर्शनेटली क्या होना चाहिए उनको पावर है। तो आप ये पॉइंट वहां पे रखवाइए।
जी
तो लेट अस सी व्हाट हैपेंस देयर।
ठीक है सर। और
यहाँ पे इस इशू पे तो जो आपने रेज किया हो तो है ही है। इसके अलावा आपको कोई अदर बाकी जो भी इशू आपको लगते हैं इसमें कोई कोर्ट की इंटरफियरेंस से कोई एक सिस्टम में बेटर इंप्रूवमेंट कोई हो सकती है वो आप यहाँ इस रिपोर्ट को लेकर के आइए। Mr. Solicitor, you just in this matter you find out that that amendment part we were just
That I had a detailed discussion. We are examining it. Lord, the difficulty I'll share candidly with the court, which I was, Lord, given, that the physically handicapped category is already there in services, etc., etc. But many a times it is found that even that is being misused. People who are not physically handicapped, they are also getting into Lord, senior services like civil services, etc. So we will have to find out some definition because a few drops of, for example, acid may not qualify.
You have to plug the gap.
Yes. Otherwise, we are working on it. But immediate response was this, that we will have to take care that somebody does not misuse. Not in her case. She is a genuine case. There may be, Lord, some misuse.
So, Milords, in this case, what we are trying to say is not about any acid which is falling on the body. That is already covered under the RPWD Act, and the disability is being assessed as per the guidelines which are set down. But what we are talking about here is those people who have been administered with acid. So the damage
I don't think there
may not be visible outside.
Can you give me a note?
Sure.
Madam के साथ बैठ के just prepare a note. What is already available?
What is your suggestion? Maybe that major part of it there should not be any quarrel about it. But then the nitty-gritties, and while drafting anything, one has to always keep in mind that is this provision is capable of misuse also. Because sometimes the genuine people are left behind and the masqueraders get benefit.
Yes.
So that part we should avoid because the benefit must go to those for whom it is intended and for whom it is meant for.
Yes, my lords. So for this purpose, we had also approached various doctors as well who deal with gastroenteritis and other allied diseases. So they had also said that there is a very stark definition between people who are administered acid and people who are forcefully administered acid. So this petition we have filed keeping in mind only those victims who have been forcefully administered with acid and against whom there is an FIR which has already been filed regarding that. So this is what we are considering.
Just give a detailed note. I'll, my lord, I assure your lordship, we are working on it.
And sir, मुझे ये लगता है कि कोई भी खुद से एसिड जबरदस्ती नहीं।
No. This angle was not there. That this is the category you are. I thought any acid victim throwing of acid, etc. I never knew. Nobody would consume, obviously.
So actually there is an assessment guidelines which is already existing which is read along with the RPWD Act, and it is being used by the medical doctors so that they can rein the disability percentage.
I think what learned solicitor general is pointing out is only that some people that there should not be any loophole in the drafting that people can misuse. On judicial side, I have dealt with a case where we set aside the High Court judgment and also quashed the appointment which was secured on the basis of physical disability. Disability was that with regard to movement of the left leg. But ultimately when the state was disputing, we referred the boy to AIMS here and constituted a medical board. Eventually it was found that he is absolutely normal. And there was a medical certificate obtained from a civil surgeon regarding that disability. And argument was the High Court allowed the claim that one certificate is issued, you can't question it. The state said if the certificate has been procured fraudulently, why can't we question?
Yes.
So we said that, all right, to resolve this fact, we will refer him to AIMS. And what we found from AIMS was that he is absolutely normal. So that is the idea.
I understood you, Milords. I bow down to that. But our grievance is that no certificate is being issued to
All
us.
right, that is what we are suggesting, that will be taken care. And meanwhile, you think of what else can be done.
Sure, Milords.
The additional facts mentioned in IO number 320840 of 2025 are taken on the court. The same shall also be read as part of the pleadings. The Union of India may consider all the issues. Learned Solicitor of India states that all the issues raised in the petition will be duly considered and an appropriate policy framework will be prepared. That we need to be done within a period of 6 weeks.
Yes,
6 weeks. Then suppose the matter on so and so date.
you give me the note, detail note.
Next paragraph, we have also taken notice of the stage of the trial currently pending before in the Rohini courts, Delhi. That's all. Next paragraph. A compliance report has been filed by the state of J&K and Ladakh.
It was the High Court, Milords.
By the High Court, by the High Court of J&K and Ladakh. We request the High Court to issue necessary instructions for prioritizing the conclusion of trial in all the 5 pending cases. Subject to any other trial involving a grave nature of offences. As request the matter on so and so day. Meanwhile, the notice has been issued to all these states or?
Your Lordships did issue, my Lord, directing the Registrar Generals to report to your Lordships about the number of such cases.
I think for the states also, we may hear and because they are at the state level also, there are various welfare policies for specific.
Subject to your Lordship's approval, it can be done through the standing council so that time is not wasted.
Let notice be also issued to all the states, the union territories, to their respective standing council. Registry shall forward the soft copy of this petition to all the standing councils, returnable for the date fixed.
सर हम बड़ी होप लेकर आए हैं, प्लीज आप इस पे कुछ मतलब उन सर्वाइवर्स को जब मैंने जाकर उस दिन बताया जिनको एसिड पिलाया जाता है वो इतनी खुश थी कि पहली बार किसी ने बोला और इतना पॉजिटिव रिस्पांस मिला, तो सर आप प्लीज इसको देखिएगा क्योंकि सर उनका मतलब आप सोचो 28 साल की लड़की है जिसका वजन 20 किलो रह जाता है, हीमोग्लोबिन 3 रह जाता है, वो कैसे अपनी जिंदगी में कुछ कर पाएगी, तो बहुत ही सीरियस है उनकी कंडीशन। सर आप प्लीज इस पे देखिएगा।
आप कोई पर्टिकुलर केस की बात कर रहे हैं
सर? एसिड इंजेक्शन वाले केस की बात कर रहे हैं।
एसिड पिलाने वाले केसेस की बात।
पिलाने वालों का आप अगर कोई 1-2 केसेस का कोई इंस्टांस अगर हो जहाँ पे ट्रायल पेंडिंग हुआ कुछ भी, या कोई ऐसा केस आपको लगे जहाँ पे ऐसा इंस्टेंस तो हुआ लेकिन पुलिस ने कोई कार्रवाई नहीं की, तो आप लाइए रिकॉर्ड पर, अगर आपके कोई नोटिस में है तो आप उसमें हमारी मदद कीजिए, और नहीं तो आप हमने सारी स्टेट गवर्नमेंट्स को बुलाया उस दिन जब स्टेट के काउंसिल होंगे यहाँ पे, तो आप उस दिन बताना, उस दिन हम उनको डायरेक्शन देंगे कि आप अपने अपने पुलिस स्टेशन से उसे वेरीफाई करें कि ऐसी कोई कंप्लेंट्स कभी आई है क्या, अगर आई है तो उस पर क्या कार्रवाई हुई, उसका हम रिकॉर्ड लेंगे।
There is a provision, there used to be, I'll check up, used to be a provision in CRPC, must have continued, that at the time of conviction, the court can direct the accused.
57A.
Yes.
Scheme.
Yes, my lord. To compensate the victim.
Yes.
Are there.
No, even victim will have, the accused will have to compensate the victim.
That unfortunately, I think there is a...
What happens, Mr. Solicitor, is the accused generally comes from very weak economic.
He also may not
So
afford.
what is done is a balance between the schemes under the NALSA authorities as well as the states. Every state government has formulated.
Because at the end of the day, this is state's failure.
What they are really trying to flag is most of the acid victims are victims with scars on the body, but there can be internal organ damage
Damage also.
because of the ingestion, where there is no scar on the face, no scar.
And that is more
Yes,
dangerous. and
yes.
it is more.
Bound to burn
Various
the-
vital organs of the
very
body
sensitive
will
organ of
be
the-
irreversibly damaged, which make them wholly dependent on medication or some other support.
If at all, if at all.
If at all.
If at all.
So these cases, whether they can be covered under the PWD statutory scheme.
I didn't know, my lord.
Yes,
When,
that is what they are.
yes, that is, my lord. I am clear now.
First of all, there should not be any, in fact, second opinion that this kind of matters must go where the victim has survived. The matter must be under the corresponding provision of 307.
Correct.
It has to be.
It has to be.
And I recollect in one of the family cases, it was treated to be 326 where I disagreed and I converted into 307. So it has to be. Where the victim survived, there should not be any second opinion that a corresponding offense under 307 must be there. And secondly, this special ability, because that is bound to cause irreversible damage.
I thought it's acid throwing.
No,
But this is a different dimension.
And this is where, as Mr. Solicitor, you have rightly pointed out, there are schemes and also statutory provisions under the Code of Criminal Procedure 357 capital B, which there is a corresponding provision in the BNSS, where free medical aid can be provided to such victims because these victims require perpetual medical assistance. When the alimentary canal or the food pipe is damaged, they will require continuous and regular long-term treatment, which may not be available to a victim coming from an economically weak background.
No,
So
and
if
ultimately,
schemes
my
or
lord, let us be clear.
Central government and state government hospitals can be
Must
brought
be,
under
because
the
at the
scheme.
end of the day, this is the failure of
Sort of
the state in broader sense.
Also, schemes are doing well because under those schemes we are getting some funds from the state governments and the central government. So that corpus with every state legal service authority and a liberal utilization of it under the constant monitoring of the NALSA is working reasonably well. But there also we are facing
permanent treatment. My lord,
there also we are facing problems. Some of the states on the ground of financial crunch, they are not releasing. I have been facing this problem. There is a like inordinate delay on the part of several states. They don't release the annual grant for that. So for the time being, the state legal service authority which were in crisis, I had diverted some NALSA funds so that the scheme is not
Lordship
frustrated.
may issue that direction as well, my lord, because it's a matter of priority. My lord. You have to prioritize your disbursement also.
But I think the corresponding provision in CRPC, where compensation from the accused, probably there is some maximum tag of amount, and that amount is completely unrealistic.
The discretion of the
And Milords, regarding the compensation or the penalty arraigned to the accused, in that context, if you are speaking, we can see how much longer the trial is taking. So at the end of the trial, when the judgment is eventually passed, that is when the accused is being arraigned the penalty. So when the acid attack survivor is getting the penalty, it would be too late for her.
She may not, in some cases, survive also too. I'm
Exactly.
sorry to say this, but it is so dangerous, my lord, to swallow, to made to swallow acid, my lord, is something
Yes, sir.
Horrendous. It's barbaric.
All the internal organs get affected. Whereas
You
on the
survive only,
outside, the body
only
is,
part of your body survives.
It will rupture everything wherever it will touch.
It reaches.
There's no question of.
And Millards, in most of the cases of these forceful acid ingestion, it is a case of domestic violence, which is usually perpetrated by either the husband or the in-laws. So in that case, there is already a pressure mounting upon the victim because they compel her, either you give a statement in favor of the accused or else you will be on the road. So she has to decide whether she has to live or she has to survive.
Yes, sir.
2-3 amendments that maybe that this definition of specially able, then in the penal laws also, in the penal laws and in the bail provision also, there can be an exception can be added that in some of these offenses like this, there is the most ruthless, most heinous kind of brutality it exhibits when somebody does it. There should be stringent conditions more than this UAPA or PMLAs or.
This is animal instinct.
This is absolutely
not human instinct.
These people have no right to roam in society.
Absolutely.
They are threat to the society. They are threat to the civilian people. They are threat to the rule of law. And the law and the system must deal with them by iron hands. So that stringent condition bail can also be
Acts as a deterrent for future also.
A befitting preventive measure.
सर एक चीज मैं और ऐड करना चाहूंगी, जैसे अभी नालसा की पॉलिसी के बारे में बात हो रही थी, तो नालसा की पॉलिसी में है डिसेबिलिटी का इतना है, आपकी बर्न इंजरी है इतना है, तो उसमें भी एसिड इंजेक्शन वालों को कुछ बेनिफिट नहीं है क्योंकि उनको वो सब चीजें ना तो बर्न इंजरी दिखती है ना
The difficulty appears to be, she is right. Difficulty appears
नालसा का बेनिफिट उन्हें कभी नहीं मिला। सर जो मिनिमम मुआवजा है 3 लाख, वो सिर्फ वहां तक ही जा पाते हैं, उससे आगे कभी उन्हें कुछ नहीं मिला।
तो नालसा की स्कीम है।
हाँ सर, जो नालसा की स्कीम है
Lord, in my lord, right to physically weaker, my lord, I'm sorry, persons with disability, the acid attack victim is defined. This needs to be, my lord, amended. This is my personal view.
disfiguration.
Means,
On disfiguration.
no, my lord. It says, means a person disfigured due to violent assaults by throwing of acid.
Yes.
No, not only that. See, disfiguration. So it stresses on the external disfiguration
and
not
throwing.
On the, on throwing.
And throwing.
And not on the internal damage of organs.
This needs to be.
This needs to be.
This definition is where? In the
No, this is in
WD Act.
right to this rights of persons with disability Act. There is a definition, but this dimension of forcibly drinking was not in my mind. I was also,
Addition of one explanation will take care.
well, yes. And your lordships are right. Disfiguration again.
The word is disfiguration. So even the schemes, they all go by the proportionate disfiguration on the external.
Like burn injuries.
Yes.
Any irreversible loss to the external or internal organ.
Yes.
Will be treated as
Whether by throwing or
Other way.
or forced to drink.
Apart from self-ingestion.
apart from
Self-ingestion,
yes, ma'am.
where a person seeks to commit suicide by
Sometimes
ingestion.
people take it to commit suicide.
Yes.
That may be a
That
different
may
kind.
not be within the scheme, but otherwise, any hostile
Forceful under
administration.
coercion or something.
So that is why Milad, the definition under the DNS, which is existing, that covers both the
That covers.
but the RPWD Act does not cover it. That is actually our prayer, so that we can get a purposive.
Provide the Solicitor General with a note as you want.
Let us get the note.
We will take up after 6 weeks. Let us see then what kind of response we get. About this NALSA scheme also, you make a mention, we'll see that because I have dealt with recently, there are budget allocation issue, but we'll try to find out some solution. We bring that also on report that I know the cap of 3 lakh right now.
Yes, sir.
Obliged to.
Deeply obliged, Milad. Thank you, sir.
May I mention just one IA, it is in relation to item 28. It is in relation to the BLOs, my lord, who have died. Lordship, may I just there is a,
We will see later on. First, let Mr. Raju answer this.
please.
These are new dramas started in court. Yes, Mr. Raju.
Wait, please, Lordship. I've handed up a note, Willards, which has three main propositions, Willards, and I'll be arguing only 2 out of those 3 because the third is state-specific Tamil Nadu, so I'm not touching that now. The first submission I'm making for your Lordship's consideration is that there are some overarching grand constitutional principles which will inform the functioning of different constitutional bodies. For instance, rule of law, independence of judiciary. These are 2 major constitutional principles, and the judiciary's efforts are directed towards upholding those principles. Now let us come to another constitutional body, the one we're dealing with today, the Election Commission, which is the grand constitutional purpose which the Election Commission is supposed to serve. That is universal adult franchise. So the mandate of the Election Commission, as envisaged by the Constitution, is to facilitate the ideal of universal adult franchise. Now, how does the Election Commission view its role? Because depending on how it views its role will follow how it acts. Either it sees its role as a facilitator and enabler of this ideal of universal adult franchise, which would mean helping citizens to vote, proactively helping and enabling. The negative way of viewing one's own role is that of a disabler or that of a suspicious policeman. So depending on how you view your own role, your sense of fairness, how you go about a particular exercise will be apparent from that, Mills. Now, Mills, the 3 major qualifying factors for voting for this universal adult franchise will be age, residence, and citizenship. Out of these 3, not one is more important than the other. All 3 are equally important. And if these are satisfied, then the exercise of the Election Commission is to enable those who fulfill these requirements to vote. Keeping that role in mind, Mills, let us look at the impugned order, which is a continuation. The impugned order in these cases of 2710 is a continuation of 24/6, which was passed in Bihar, where certain considerations are mentioned. Since the files are not here, the impugned order as far as these 9 states and 3 union territories are concerned, I'm handing up separately. Minutes. Show me also. Yes. You go back to the Bihar. Go back to the reference to Bihar. Yes. Yes. The first paragraph itself indicates that it's in continuation of the Bihar order of 24/6. So the purpose of this exercise now being carried out in substantial parts of the country
is a continuation of the purpose stated in the Bihar order. And what is that purpose, brothers? Paragraph 7 of 24(6), your lordships have seen it several times, but for just the emphasis of my argument, I'm reading out. Whereas the commission has noted that during the last 20 years, significant change in electoral roll has taken place due to additions and deletions on a large scale over this long period. Rapid urbanization and frequent migration of population from one place to another on account of education, livelihood, and other reasons have become a regular trend. Some electors obtain registration in one place and then shift their residence and register themselves at another place without getting their names deleted from the electoral roll of the initial place of residence. This has led to increased possibility of repeated entries in the electoral roll. Thus, the situation warrants an intensive verification drive to verify each person before enrollment as an elector. So this is the purpose. The purpose here is not to eliminate non-citizens. That is not the worry. That is not the stated worry of the Election Commission while embarking on this exercise. Therefore, the first submission is going to be that since this was not your stated purpose at all, then to start with the BLO's suspicion, the BLO's presumption of why someone is not there, that is alien to this exercise because this was not the purpose at all. Unlike your lordships had a direct case in Lal Babu Hussain, which has been read several times before. There the entire purpose was areas in Bombay and Delhi which were said to have large number of non-citizens. The entire thrust of that exercise was therefore to remedy that ill. And even there, my lords, this honorable court found procedural flaws, breach of natural justice, and therefore this honorable court passed guidelines. Today, that is not even your stated purpose. What are the guidelines for the BLO to suspect or for the ERO to suspect? I'm coming back, my lords, therefore, to the power of the Election Commission in a situation like this. Yes, constitutionally conferred, but to be read in the light of what your lordships have held, mainly, my lords, in Mohinder Singh Gill. That has been read in extenso to your lordships. But what I wish to emphasize, without taking my lords to paragraphs, is that this is a kind of a reserved power to be used in surprise situations. And you cannot shake off the shackles of statutory prescriptions. So Article 324 occurs just 3 articles before 327. 327 is part of that same scheme for the Election Commission. Therefore, if Parliament, the Constitution has given Parliament the power to enact laws to facilitate or disable electors, then that is a scheme in place. Therefore, this question of citizenship is the primary concern of the authorities under the Citizenship Act and now the recently enacted Immigration and Foreigners Act. That creates a scheme where complaints can be made, inquiries can be made, quasi-judicial inquiries are made. So that is where not just the state, but even the suspicious neighbor will come in. Therefore, if in my neighborhood I find a concentration of non-citizens, I, as a concerned neighbor, can set the law in motion in order to disable persons not entitled, not just not entitled to vote, but also not entitled to the other resources of this country, from drawing upon those resources. So there is a statutory scheme. When there is an adequate statutory scheme, then does the Election Commission also have the power to be the second suspicious neighbor or the more suspicious neighbor or a nosy Parker, so as to ask the BLO to start doubting? And kindly see what is the consequence of this. So starting with the BLO's doubt, if my name can be removed from an electoral roll till I follow those appellate processes within whatever timeline is prescribed, whether that's satisfactory or not, we'll come to when we come to the timelines. But till then, it amounts to giving the Election Commission the power to suspend citizenship, because the right to vote, the constitutional right to vote, may not be a fundamental right to vote, but that constitutional right also flows from other constitutional rights like 19(1)(a), it flows from 21, also 14, to not be treated arbitrarily. Effectively, this removal from an electoral roll on a suspicion amounts to giving a power to suspending citizenship. And does the power of the Election Commission, however plenary, extend to such a power which has the consequence of effectively suspending a person's citizenship? My respectful submission is no. This is, my lords, to repeat, not a surprise situation. This is a situation which the law has contemplated with the enactment of the RPA 1950 itself. Then, where is the scope for the Election Commission to almost play a vigilante role? And one of the queries from the bench, from what we have been following in the course of the arguments, is, does the Election Commission in this situation not have an inquisitorial role also? My respectful answer would be no, in the face of a clearly defined statutory scheme which provides for proper determination, adjudication, appeal, etc. And therefore, my lords, the impugned notifications which are enabling this kind of disenfranchisement and effective suspension of citizenship in the course of an exercise which doesn't even contemplate this as one of its purposes, because the purpose is only to check the consequences of mass migration. and urbanization, then where does this come from? And Mullards, the citizen has to satisfy when he or she fills up Form 6. All three ingredients, he or she has to state the age, the residence, and a declaration, a self-declaration of citizenship under pain of prosecution. Now, if we are to, just as part of a mass exercise, suspect, then let us suspect also the driver's license which says age. Let us suspect the ration card which gives address. That can't, with respect, be, my lords, the scope of exercise of power of a constitutional body whose larger purpose is to enable the exercise of franchise and not to disable.
But Mr. Ramchandran, wouldn't you enabling would mean also ensuring the sanctity and purity of the process?
Absolutely, my lords. There can be no quarrel with that proposition at all. Superintendent's control, etc., does not mean turning a blind eye. Does not mean turning a blind eye.
You mean someone has to goad them into action? They would generally act as an inert body.
With respect, no. That is not what I am saying.
Why I put that proposition of inquisitorial exercise is because there's a clear distinction in administrative principles of an inert adjudicatory quasi-judicial body deciding on issues of complaints of citizenship under Form 7 and adjudicating it or going into a quasi-adjudicatory role, and secondary and supplementing it. The issue which I posed was the constitutional imperative of superintendent.
Lordship, please.
Will that exercise word superintendence, which must be seen in its, you see, superintendent, as you said, the verticals of constitutionalism of judiciary, Article 227, superintendence of subordinate court by the high courts. If you see the word superintendence there, does it mean that the courts, when it is in the domain of administration of rule of law, await a complaint, or they can themselves indulge in some purifying or let's say sieving processes, undertake this? And if you see it from that angle, calling in for enumeration imperatives forms, which are more or less overlapping with Form 6.
Lordship, please.
Form 6. And that is why we did a bit of a course correction on Aadhaar. Because when statute provides for Aadhaar as identity, it should be included, and the election commission did a course
that,
correction.
fortunately.
So this situation, what we actually intended to say when we spoke of inquisitorial role is this suo motu exercise of checking on a constitutional imperative of citizenship.
Lordship, please. Now, Lordship will give me.
Once we recognize the no blind eye theory, rather than it becomes an obligation on the commission as a constitutional obligation, then some kind of, depending upon the parameter, the width and length, but a fact-finding inquiry exercise has to be undertaken by the commission.
And that scheme.
1. 2, in such a fact-finding inquiry, if this theory of that no blind eye is to be applied, then can't we, is it something, the commission exceeding the limits when it go into the genuineness of a ration card or genuineness of a Aadhaar card, knowing fully well that in mass production of this kind of certificates, cards, which are completely ingenuine, fabricated, not verified, unverified claims are available.
Well, I would respectfully submit that the Election Commission must start from a position of trust, not from a position of suspicion, because you're dealing with the entire population of the country. Your trust can be betrayed if someone makes a false declaration. So you prosecute that person. In any case, sections 21, 22, 23 have a scheme by which the electoral roll is corrected. Your name is... Now for
Mr. Ramchandran, then you see, suppose you and Mas accept all these documents and complete your exercise. And then you start getting complaints from every neighborhood, from every part of the country, that these are all false documents, fabricated documents, these are not genuinely issued, people have misused it. Will it give a better picture of the internal or external functioning of a constitutional body, or is it well advised for them to go a fact-finding summary inquiry, find out at the very beginning itself, and ensure that there are no loopholes left?
I bow to my Lord the Chief Justice's concern, and let me try to answer that. Coming back to Lal Babu, the problem which was present in the Commission's mind, whether it performed the exercise satisfactorily or unsatisfactorily is a different matter, was the problem of non-citizens in two areas. They were well within their power. The manner of that exercise of that power was different. Here, the purport of my submission is this. You may have that power. I'm straight away saying, no, you don't have to turn a blind eye. No. But if that was not your concern in the first place, even when you started in Bihar, you were talking of mass migration and urbanization.
Chandan, you are qualifying migration as a migration inter-country. The word migration can be trans-country.
It can be. It can be. But
when you use the word migration, does not necessarily mean lawful
let us see
migration.
the context in which it is used, not as a word by itself.
No, that's what we are saying. As a word, migration does not have a domestic import.
Not necessarily a domestic import. It can be an exodus, as happened.
It can be an exodus across international borders too. That's also a migration.
Mass was something which was said in the course of argument. It talks of rapid urbanization and frequent migration of population from one place to another on account of education, livelihood, and other reasons. This was in fact so Bihar specific.
Sir,
for the reason
migration across borders as much as across internal states
Lordship, please.
are on economic gradients.
If
it is the livelihood which drives people from their homes to foreign shores.
Lordship, please.
We have brain drains. And that's also migration.
Lordship, please. But my endeavor is to show that would be an extra charitable interpretation.
From my state to Bangalore.
This is dealing with legal migration.
That's right. That's the point. You're being extra charitable. Good.
Then at least from the city I hail, there are flights which are completely booked of IT personnels going from their states to southern states for livelihood.
Yes, sir.
So that's a domestic migration.
And from the southern state where I hail from,
someone goes to outside the country, it's also migration.
So from the southern state where I hail from, those flights go abroad.
So the migration, you are qualifying migration by an inbuilt limitation.
With respect,
that is migration within the country.
I would put it with respect slightly differently. The interpretation which my Lord is putting to me is an extra charitable interpretation to words, to an idea which was not intended at all
which had been advanced to us and which you are also taking forward on a much esoteric plane is the idea of citizenship is alien to the reasons given in the SIR itself. And it was said it was migration, domestic urbanization. But I put a question to you. The cities in India are more urbanized, economically viable for our neighboring populations. Will not the movement of those population across the international border amount to migration?
It would, but not in this context for the reason. I repeat.
Like say in North India, the trains, full trains of the farm workers coming from Bihar and from other states. And unfortunately, some of those persons who exploit them, working as their agents and virtually auctioning their labor in the Delhi railway station, those left out Panipat railway station, then, like this. And by the time they enter Punjab, all of them are in peanuts. The work is taken from them. The work contracts are given to them. These are the practical scene experiences for years together. Maybe now that in Bihar also.
No doubt, Minister. No doubt. What
Odisha, West Bengal even.
Without meaning disrespect, I'm repeating that. If they're home. Yeah, that's right. Right, thanks. Yeah, thanks. Exactly, that's what I'm going to say. That's exactly what I'm going to say. That's my next sentence. That's my next. Milords, Milords, without disrespect, I'm again saying that the view being put to me is an extra charitable view. The reason why I say this is on 24/6/25, the expression illegal migrant was a well-known expression in social and political discourse. And it is not a bad word, unlike some bad words which have been used for illegal migrants. But illegal migrant is a legitimate description of someone.
Migration should be read in contradistinction to illegal.
Lordship, especially because if I read this sentence, I read this again. Rapid urbanization and frequent migration of population from one place to another on account of education, livelihood, and other reasons have become a regular trend. First sentence. Some electors obtain registration in one place and then shift their residence and register themselves at another place without getting their names deleted from the electoral roll of the initial place of residence. This has led to increased possibility of repeated entries in the electoral roll. Thus, the situation warrants an intensive verification drive to verify each person. Therefore, it is only talking of intra-country, intra-constituency.
They are, according to you, this is basically largely domestic.
Absolutely domestic, Milords. In fact, I want to give my own.
Ramchandran, see like this. You will find not only Delhi is a big city, it's a national capital. So therefore Delhi, from every part of the country, people will come. In Punjab, you will find so many villages where now Gram Panchayat composition is comprising of those people who do not originally belong to Punjab, because they have spent virtually their lifetime there. They came as child laborer, they settled down, maybe their parents came there. They ultimately born, brought up or grown there as farm laborer. They have slowly earned some money, their houses, have started staying in Punjab. Now they are more mixed up with Punjab culture. They have become local voters there. If you go by their name, go by their small festivities, their culture, you will find them not so mixed up with Punjab. But They are settled in Punjab.
Lordship, please.
And their roots are there in Bihar, Odisha, West Bengal, or any other state, southern part of the country. Now, this is what a part of it. But see the other face. They are entering Punjab, and youth of the Punjab, through all kind of illegal means, legal means, is migrating. So the space which they occupy is actually vacated by Punjab people. So this will address both.
Lordship, please. But the focus, I repeat, here is only this. Let me give, my lords, if your lordship don't mind, my own personal example, my lords. Till recently, I was a resident of Uttar Pradesh, Noida. Because of certain changes in my life, I have moved to Delhi. My booth level officer proactively, she was the one who facilitated making of an voter's card for me. She said, sir, you seem to have sold your house and gone. Can I delete your name and you can get registered in Delhi? I said, yes, I admired her proactive approach. And in deleting my name, it is that kind of a situation which is being addressed here, not someone coming from a foreign country. Therefore, my lords, the very scope of what the Election Commission saw as its concern was not that at all. And then, as a kind of a spill-off, can ancillary powers extend to this, minutes, that if the focus of your exercise is circumstances A, B, C, D, E, your BLO can also look at something else and then suspect and just remove from the role, minutes. See the drastic consequence, minutes. See the drastic consequence of this being done in the course of an exercise where this was not the stated purpose. So even the basic level of training, whatever camps they may have held before starting out this, could not have sensitized the BLOs or the EROs to this at all, that before you remove someone thinking that he or she is a non-citizen, this is going to be the consequence. So please apply these safeguards. That is not there. And that is why I come back to my original point, and I've then finished with proposition 1, that this plenary power, this extraordinary power, this power in reserve is to be exercised carefully, cautiously, when there is a well-conceived statutory scheme and considerations of urbanization, etc., have not thought of this as a problem, then it is dangerous to give this power, and that exercise of power renders it unconstitutional. I'm putting this within the larger scope of the power under 324. I now come, Millards, to my second proposition, which is the impugned order does not disclose any relevant or valid reason connected with any legitimate state aim to justify a special revision under 21(3) of the Representation of People Act. Now, Millards, and I've indicated the fundamental rights from which this right to vote will flow, apart from the constitutional right itself, Millards, under 326, but flows from 19(1)(a), flows from the right not to be treated arbitrarily. My right to dignity includes the right to political participation. Now, Millards, therefore, we have to apply the constitutional tests of proportionality. Now, Millards, 21(3) no doubt gives the power to carry out a special intensive revision, apart from summary, special. And your lordships have seen that this can be in any constituency or part thereof. The language of 21(3) is any constituency or part thereof. The question which fell from the bench in the course of the hearings was, cannot any mean all? Let me concede that any can be more than one, without going to the extent of saying any means all.
It can be many.
It can be many. Many can extend conceivably to a full state also. Let me go so far as to say any constituency or part of a constituency in Bihar can extend to the whole state of Bihar. But can we stretch that to say, as has now been done by the impugned order of 2710, 9 states and 3 union territories? And I'm not going into state specifics. I'm only reading out the names of the states. Yes. And then give me that language of the migration, etc. Come. Now, this impugned order of 27th October, I'm appearing in the Tamil Nadu case and I'm appearing in a Chhattisgarh case also. Chief Electoral Officers of Andaman and Nicobar Island, Union Territory, Chhattisgarh, Goa, Gujarat, Kerala, Lakshadweep, Madhya Pradesh, Puducherry, Rajasthan, Tamil Nadu, Uttar Pradesh, West Bengal. So in other words, rapid urbanization and frequent migration of population from one place to another on account of education, livelihood and other reasons have become a regular feature, not just in Kerala or Madhya Pradesh, but it is assumed to be a regular feature of Lakshadweep, of Andaman and Nicobar.
Also, yes.
Also, that is with respect. That is with respect, my lords, a very facile, easy and lazy assumption to make that each one of these stated considerations applies to 9 states and 3 union territories. On the face of it, my lords, in my respectful submission, it shows non-application of mind. And when 21(3) gives that power, yes, not just to any constituency, but to many constituencies.
No, but if, Mr. Ramchandran, these small pockets or big pockets where the islands or a state, bigger state like Rajasthan in terms of geographical area, if they have experienced massive migration of coming or going, then how to draw distinction between them?
All that I am emphasizing, my lords, is...
See, in June, I'm completely out of context, I'm sharing the experience. In June, first time, the NALSA conducted a program at Havelock Island. And probably I was the first person looking after Nalsa who reached there. Then I started inquiring from the local people meeting there. And I found that out of 25,000, about 25,000 population, more than 22,000 are the migrants coming from Bengal, coming from Tamil Nadu, coming from other parts of the state, even the people from Punjab. So all were there. And this has happened during only 15-20 years maximum. Otherwise, we do not know where the poor original habitats of the, where are they hiding and where have they gone.
I am grateful to my Lord the Chief Justice's intervention for this reason, that this is based on personal observation of the learned Chief Justice, having gone there. Now, my lords, what are we expecting from the Election Commission? What are we expecting from the Election Commission today? You have this vast organization, this vast bureaucracy all over the country. You have the power to co-opt from the states. You penalize the states if they don't depute a particular officer, etc., etc. For this plenitude of power which you have, you pass copy-paste orders, minutes. How can that be, minutes? So therefore, your Bihar reasons of 24(6) are to be read in the manner of legislation by reference or legislation by incorporation into one omnibus order for 9 states and 3 union territories. Does the language of 21(3) notwithstanding anything contained in subsection 2, the Election Commission may at any time, for reasons to be recorded.
That this order interestingly includes the largest areas and the smallest both.
Lordship, please.
Because Uttar Pradesh in the country.
Lordship, please.
Then Rajasthan, Tamil Nadu are also very big. Madhya Pradesh is a very big state.
Lakshadweep.
And Lakshadweep is the smallest, maybe smallest island.
What I am taking pains. That's right. That's right.
Just yeah, that's what it is. Justice is like that. Justice is not done. It will seem to be done. It's exactly.
अभी तक ठीक चल रहा है, समझ में आ रहा है ना? Yes. I won't go back down. I won't open up afresh. I'm almost.
Justice must not be never be seen and with an application of money must not be there, must be shown to be there. That's the point.
Yeah. No, I will emphasize the meaning of recorded. It's not recited. It's not stated. Sorry. My mind is.
So in the computer, this is what independent reason. Is it?
Yeah, you mentioned that. Yeah, I read it. Give me that table. Yeah. That's the result.
7 districts.
You also will keep in mind, SIR cannot be, in terms of procedural modalities. We can't think of interfering too much and suggesting them a procedure which becomes an annual feature. SIR is not an annual feature. Can't be annual feature. In fact, if they want it happen, that's why let us keep in mind that they are doing something after 20 years.
It is precisely because they are doing it after 20 years that there has to be a degree of seriousness and commitment to the purpose which they ought to show, which I want to show, they have not shown. Section 21(3) says, for
But
reasons...
If they start copy pasting the electoral rolls based upon whatever documents they have, what will happen? Then it will be nothing but a replication of the annual publication of annual voter.
Lordship, please, but the Election Commission can't copy paste its own orders for 9 states and 3 union territories.
No, that's right.
For the reason. I'm sorry, my lord is saying.
Yes, because the reasons mentioned in the original order are pan-India, as you are also rightly saying. So therefore, that reason which exists there for A state, that reason has its impact on the B state also.
With respect, my lords, therefore, let us, my lords, take, for the sake of argument, I'm not conceding that, but let us, yes, let us take...
This is not the opinion of the court or your opinion. We are only trying to understand.
Your lordships are always
open. Put to you are not our conclusion.
Not at all, my lords.
We have to evoke better response from you.
At least Mr. Dwivedi and I, who have crossed the age of 70, my lords, we have enough experience to know.
It's only for the dialectical dialogue.
Absolutely, my lords. Which we
unless we give some homework with grilling questions, how will the best will come out?
Absolutely, my lords.
That is the
and we often go home asking, why hasn't judge asked any question? That's also a problem which we have, my lords, when the judge doesn't ask a question. My lords, my submission is this, my lords. 21(3) says, reasons to be recorded. There is a certain sanctity about recorded. It is not reasons to be stated. It is not reasons to be recited. It is not a mantra which is to be mechanically repeated. Therefore, the least that was required, going by the example which my lord the Chief Justice gave, my lords, of what he observed in Andaman, the least that was required in this nationwide, virtually nationwide exercise was for the Election Commission.
But there it was a very pleasant experience that how people from different parts of the country are living so happily and they are so satisfied life.
That is real. Andaman is really,
which you badly find missing in the urban areas, the so-called cosmopolitan and metropolitan cities.
Though that is true, minutes. Andaman is really...
Yeah, with their small, requirements and with their limited ambition, they are extremely happy.
Lordship, please. Now, my lords, therefore, the least...
Tribal areas.
And आप लोग shorts पहन के जाते हो.
Then, our experience, because I have come from a high court which again has the superintendence over the island. The crime rate, particularly the crime rate against women in the tribals was near zero.
Yes, ma'am.
Till they came in interface with the so-called civil
urban. Lordship, please. Lordship, please. Tribal civilization is so much more respectful. Malad.
Hardly any sexual offenses because the equality of the sexes in the tribal culture
Yes, Malad, absolutely.
is unique.
Yes, Malad. Across the world, Malad. Any study of tribal populations indicates, Malad, the absolute equality, Malad, of sexes. The least, my respectful submission is the statutory requirement of recorded as against merely stated or recited requires application of mind and demonstrable application of mind to facts and circumstances. And to pass an order for Bihar on 24/6 saying this is what is applicable all over, but just now we are concerned with Bihar. We'll see later. So Bihar was urgent. You did it. What was the urgency to pass this kind of an omnibus order without applying?
But sir, if you see the Bihar order, the application of mind was already there that this ought to be a pan-Indian exercise, but Bihar was being implemented. So to say, we don't know, that would be the election commission was to say why they chose Bihar, but they said that it was like the first step of the long and pan-India project.
Therefore,
24/6.
But that very order, my brother is right. That very order is cites
That order
expressly.
itself says
That is already exercised.
It does.
And Mr. Ramjivan, it's if you see the nature of reason again, it's a population migration. So migration from one to another would be a corollary of a check from the area where the outgoing migration takes place to the incoming migration.
Lordship, please, because within the country you have to go from.
It has to be a corollary.
I bow to that observation. I also bow to that to the observation that 24/6 itself was a precursor and indicated by itself that it was going to be pan-India.
Sir, we are responding this to sort of address the issue that you bring up as a cut and paste knee-jerk exercise.
I reiterate
exercise itself conceived of a pan-Indian role. You would definitely be well received to say that there could not have been a pan-India role in the first place. That's another way of looking at it.
I'm
But
grateful.
if you say that Tamil Nadu, Bengal, etc., were a sort of cut-paste replication of Bihar, it was already there in their mind to do it.
I'm grateful to my Lord Millet, Justice Bagchi, for helping me to nuance my argument a bit. If pan-India was conceived prior to 24/6, then there has to be reflection of the application of mind to pan-India facts, not just a mere statement that this requires to be done pan-India. Right now we are doing it for Bihar, then we'll do later. There had to be something more.
Yeah, to make your argument more pointed, you say the word migration or the word urbanization are conclusions and not reasons.
I'm grateful, Mills.
That's what you would like to say.
I'm grateful, Mills. I couldn't have put it better, Mills, with respect. And therefore,
as per Gill, they will require to give us the data why they say that migration takes place. Or can we take judicial notice that there has been urbanization in India in the last 2 decades, resulting in population movements?
And Mills, two, therefore, that a constitutional body doesn't have time or resources to show application of mind to 9 states and 3 union territories, and the urgency is such as to pass one omnibus order. Today, my lords, I'm addressing my lords on the Tamil Nadu matter, but I'm in a Chhattisgarh matter where your lordship has issued notice. And Chhattisgarh is most stark because we are talking of Bastar division. My lords, 12 assembly constituencies, 7 districts. It doesn't require much general knowledge to know that Bastar is the most unfortunately ravaged region of the country because of Maoist violence, because of Salva Judum, because of various displacements, etc. Elections in Chhattisgarh are not due till December 28. Elections in Chhattisgarh are not due till December 28. I have a chart with me to show forthcoming elections in different states. Some states which are going earlier to the polls are not part of this exercise, but an unfortunate area like Bastar, because it falls in Chhattisgarh, that gets included in this tight time frame. That is the problem, Millards, with this omnibus exercise, saying we thought of pan-India then. So now we are only fulfilling our promise. That can't be, Millards. Now kindly see, I've given various states. So kindly come to the bottom, Millards. 2028, from serial 15 onwards, there are these states from 15 to 24 which go to the polls only in 2028, out of which Madhya Pradesh and Chhattisgarh have been chosen.
Mr. Ramchandra, Assam, is it special or summary? In Assam, some people argued before us in another writ petition.
Assam will be special, Millards, but it's a different procedure, Millards.
Oh, it's special.
It's an SIR. It's not an SIR. My friend will explain, Millards.
Assam is SIR only, but the procedure they are
Oh,
following
SIR.
Different.
is slightly different. Because they are not going to the citizenship question there at all.
Because maybe the NRC is looking after that and therefore, Millards. So this is the problem, Millards. How can this meet the statutory requirement, Millards, of 21(3)?
Their answer can be probably, they will say that if we grant more time or we have a flexible schedule in these states where there is no election due in recent times, then the other states will say, why you are discriminating with us? Why are you not granting the same kind of the timeline to our state presidents also? That can be one issue. The second issue may be that this entire pan-India exercise is targeted to be completed by a particular within a time frame, so that this is over, because this can't be a feature which can be allowed to be seen as we said earlier, the annual feature or after 2-3 years that you are indulging.
No, but then if it has to be, yes, Millards, extraordinary once in 20 years, but there is still a principle on which you must choose. All right, 9 is big enough a number, but which 9? Either you say whole country, you say 9, you say 15, but on what principle? I have, from this chart, Millards, at least been able to demonstrate that Chhattisgarh, which is comparatively far off, one of the most vulnerable areas of the country, has to undergo this exercise. More facts your lordships will see when that individual petition comes up before your lordships. But this is the problem with this plenitude of power which your lordships have given to the Election Commission. I don't complain about that, Millards. It is another constitutional body, and constitutional bodies proceed on the basis of mutual trust and respect and not on the basis of suspicion. I concede that. But the exercise of power by all other constitutional bodies is ultimately subject to judicial review only by this one constitutional body before which we are today. And my attempt has been to show that in clutching at power in situations and contexts which don't warrant it, and rushing through with the exercise in the manner in which it has been done here, giving these reasons which can't obviously on the face of it apply across the board, Millards. That is what calls for the exercise of judicial review by my lords. And as your lordships will go state by state, because today I'm only making the legal submission. I have to make my Tamil Nadu submissions. I have to make my Chhattisgarh submission. But this is the foundation
with reference
of the
to Tamil
submissions.
Nadu.
I'm grateful, Millards, for a patient hearing, Millards.
It's on the.
कुछ और क्यों नहीं अभी? In any case, we'll continue with the SIR matter only. Rest of the matter will take care. We will cancel that special bench also. We'll give no special bench.
Lordship, should we considering Millards Tamil Nadu on Thursday, Millards?
Tuesday will
Tuesday,
continue.
please.
Tuesday will continue.
As your Lordship.
Your Lordship's pleasure will be to
Our main matter will continue.
Yes, of course, that's constant.
Tuesday Bihar matter in any case will continue, and already this Assam matter is also there. So after this Bihar matter is over formally, then Assam matter, or you want them to first conclude?
Millards, on behalf of
I
Tamil
think
Nadu-
they let them complete, Millards. But I am at your Lordship's, Millards, what your Lordship's wants, Millards.
So you be ready for
All that I want is, Millards, that once I start, Millards, then let me complete the whole legal aspect. Then specifics can be looked into. Or they complete, Millards, then I start, whichever way, Millards.
Let us.
So I would take about 15 minutes, Millards, on the Tamil
issue.
on legal.
Time is not the issue. We have
Great.
granting time to. We now will not in the middle of arguments will not stop anyone.
So great.
But be reasonable, and whatever time on the new points you require, those have been argued. You can skip.
Certainly.
And those which are the new factual or legal issue, please do raise them. There is no difficulty in entertaining that. So we continue on Tuesday. Then we'll see what is to be done. Next matter. What is the next matter, madam? The management Vishnupa temple.
We are government
appointed.
Your Lordship, in this matter, the Supreme Court actually has let it to January, possibly January.
When do you want?
First week January, anytime.
First week of January. First week of January, almost we are closed. We are opening on 6th after 6th January. Give a date after 6th January.